kiggeseng tool.
Recording in progress. Recording stopped. Recording in progress.
Good morning, colleagues. Good morning, honorable members. And good morning to our guests from the Special Investigating Unit. I'm just testing audio now. Can you hear me?
Good morning, Chairperson. Yes, we can hear you clearly.
Everybody can hear. That's good. Thank you very much. I'm sorry I joined a little bit late. I battled with connectivity here. I had to make an alternative plan. Today, we've got the Special Investigating Unit. It's our last day for the rough inquiry this week. And the Special Investigating Unit will update us on their investigation, but follow the pattern of our terms of reference for the inquiry. They will be part of the terms of reference that are not applicable to the SIU, to the SIU's work at the Road Accident Fund. So those parts have been left out. And they've been kind enough to favor us with their presentation for today ahead of time. So thank you very much for that. I would like to hand over to Advocate Mutibi and his team. So firstly, Advocate, please introduce your team. And then once you have done that, you can then take us through your presentation. And then at the end of it, we will then allow for questions. There might be an occasion or two when I ask you to clarify something, terminology, etc., but that typically doesn't happen so much with you because we see each other often. So I don't expect that there will be more than one or two of those. So we'll allow you to go through the presentation and then we will take a break. And then when we come back, the members are going to ask questions. Thank you so much, Advocate, and over to you.
No, thank you very much, Honorable Chair. Good morning, and good morning to honorable members of SCOPA. We appreciate this opportunity to present to SCOPA. I'm joined by my colleagues, Mr. Lekgetho, who's the Chief Operations Officer. I'm also joined by Ms. Zodwa Klesibe. She's the Chief National Investigating Officer. Also joined by Advocate Vanara, who's the Chief Legal Counsel. There's also Advocate Lebopa, who is the Forensic Investigations Specialist. She's the legal person within the investigating team. And then Mr. Maseko, who's the Principal Forensic Investigator. He's the lead investigator in this investigation. We're also joined by Ms. Rottenbach, who is the project manager, ensuring that the project is monitored, project outcomes are delivered timely. So that's the team, Honorable Chair. We will then proceed to present. I'll ask thank you very much. Honorable Chair, we will not go through the background of the SIU and the mandate. Can I request that we go to slide number 10? Can we go to slide number 10, please? Right. This is the landing page of where we're starting to introduce. We'll go through our findings and outcomes, and of course, contributing to the oversight inquiry by SCOPA, having looked at the terms of reference. But if you go to the next slide, it really seeks to say we will assist the SCOPA inquiry by presenting our preliminary findings. Well, we're calling them preliminary because the investigation is not complete, but to the extent that they've been finalized, we are able to take actions on those. We will then, these findings also cover matters that fall within the purview of the inquiry. And we do indicate that there are certain aspects or topics, of course, that we have realized that they fall outside of the scope of the proclamation. However, we're saying in such cases, we will report any relevant observations, if available, or indicate where the matters fall outside. Can you please keep the slide stable, please? Will indicate when to move. Where the matters fall outside of our investigation scope, we are indicating that those matters can then form part of the referrals that SCOPA may make at the conclusion of the inquiry, and they would either be included in the current proclamation, or we could then seek a new and wider proclamation. You can go to the next slide. Right, please page on. Right, Honorable Chair and Honorable Members, we looked at the terms of reference as we indicated, and we wanted to obviously contribute in line with that and indicate areas of our investigation that fall within some of those categories of the terms of reference. We will be presenting on what we view as governance failures at the Road Accident Fund, as revealed by the investigations. And Honorable Chair, just before I go into the bullet points, I thought it appropriate to mention that organizations are held to a governance standard. Although the standards such as King 4, King Code of Good Governance, would ordinarily really serve as source documents for standards of governance, we have also looked at those, but particularly for the public sector, where REF finds itself in terms of the sphere of government. We have looked at Section 195 of the Constitution, which provides for basic values and basic principles governing public administration. So REF would be held to that standard that is provided for in the Constitution in that section. We have also, of course, looked at the just general laws applicable to public administration and administrative law in particular. And of course, one of the key legislations would be the Public Finance Management Act, which we have looked at. Now, in doing so, if I go now into the content of the slide, the investigation identified certain governance deficiencies, and we call them systemic governance deficiencies at the Road Accident Fund. Those deficiencies contributed significantly to maladministration, financial instability, and operational inefficiencies. These failures reflect a breakdown in both strategic leadership and corporate governance structures. The governance failures created an enabling environment for maladministration, weak internal controls, and escalating financial risk. These systemic deficiencies compromised the fund's ability to deliver effectively on its mandate to compensate road accident victims. Specific findings and outcomes of the investigations will be indicated below. As you'll realize, we will also point out non-compliance with the Constitution and the Public Finance Management Act and the REF policies. We also will cover the procurement irregularities. Okay, you can go to the next slide. Right. The next slide now really go into some of the aspects that we investigated. As the committee will be aware that some of those focus areas were presented before. The one area we investigated was the issue around the disestablishment of the panel of attorneys, which REF had, right? Right, now we have made findings, and we are of the view as the SIU that the decision not to proceed with contracting the panel of attorneys was not approved by the board, which is problematic. Safe to say that the board approved a strategy wherein the Road Accident Fund had to reduce its administration costs, including the legal costs. Now, the question that arose in the process is, who would have approved this non-proceeding with the panel? If it was the CEO who approved, the question was was it within the delegated authority? I've asked the team to check on those aspects, and either Mr. Lekgetho or Mr. Maseko can come in, because it is important to note, the approval levels and whether there was appropriate delegation of authority. Failure of which then also really contributes to maladministration. Second bullet point, there was no plan adopted to replace the panel of attorneys. Another problematic area. Even though the former REF CEO contends that the REF employed practitioners and seconded them to state attorney to represent the REF, seemingly this as a mere ex post facto afterthought, as we put it. That would have been done not within a structured approach, but I say again, it wouldn't necessarily substantively replace the panel that was in place to ensure that REF executes on its mandate. We are of the view that the REF management acted irrationally by presenting a report to the board seeking to forego the panel of attorneys without any plan in place. And as you will realize later on, this has cost the Road Accident Fund immensely. And if it was done appropriately, it would possibly not have incurred those costs. Now, the board, as the accounting authority, in terms of the Public Finance Management Act, has got certain responsibilities and accountabilities in terms of Section 51 of the PFMA. Testing their responsibility against that, the PFMA provisions, we are of the view that the board acted irrationally by approving a strategy of foregoing the panel of attorneys without any corresponding plan to deal with the work entrusted to the panel of attorneys. This would have included the handover process. The rationale for such decision, in our view, is flawed in both public administration and we are saying also in law. You can go to the next slide, please. Right, the next slide, Honorable Chair and Honorable Members, there was another area that we looked at, which is the corporate panel. So as the team looked at these different panels, the other panel would have been the panel to enable core mandate, payment of claims, defense of proceedings. This one looked at corporate matters when probably REF is sued and so on. But this would then look at the corporate legal matters. Right. It appears that in this case, the Government Employee Pension Fund was approached to assist. And again, the basis of this really doesn't come out immediately. But anyway, the GEPF was approached to assist with the use of the law firms that were assisting them. And GEPF only had 14 service providers, law firms, and emails informing them that REF is requesting to utilize their services for the corporate panel and seeking consent in writing so that they can use this panel. Right, between May and June 2020, REF entered into an agreement with the 13 law firms that were provided by GEPF. And on looking at this contract, it appears that the contract, once this was entered into, it then got extended almost about 4 times. And the evidence indicates that it was approved only once for a period of 6 months by the board. Now, other extensions were not approved by the board. So this is another problematic area. And the payments that were found to be related to this corporate panel was 26.6 million, which we found that it exceeded the delegation of the road accident fund accounting officer. In this case would be the CEO. Furthermore, the expended amount is above the total budget of 10 million. Looks like this was the budget for the corporate panel. Now, the ratification of both entering into the contract and exceeding the delegated amount, including extensions, was done a year later in August 2021. Now, the REF board, through its chairperson, approved the ratification and extension of the contract for 6 months. In the interviews held with the officials, the ratification was for their internal process. That is in case of audit, not really ratifying the procurement process. So this is another area which we really found that it was problematic because the whole procurement process was not ratified. You can proceed to the next slide. Right, still on the corporate panel, we conducted the financial analysis, including bank statements of attorneys appointed in the REF corporate panel of attorneys. And the preliminary findings suggest that a family member linked to a REF executive was paid monies by one of the law firms appointed in the REF corporate panel of attorneys. In addition, the law firm is providing personal legal services to the REF executive. Amongst the services providers appointed by the REF, we found that there were no fair rotation or allocation of work, as one of the service providers was allocated almost 90% of the work as opposed to other service providers. As we were preparing for this presentation, I asked my colleagues, Mr. Lekhatho, and I hope you have the value, just to indicate what 90% in rent value equated to. So we apologize that we didn't put the value, but I've requested that we look at that just to give an indication to the Honorable Committee. Some law firms appointed in terms of corporate panel of attorneys conducted claims related to matters, whereas the mandate of the panel was not related to claims. So this is almost what would be called scope creep, which was not related to their mandate. The approval to invoke National Treasury Regulation 16A6.6, as well as the subsequent contract extension and related payments, were undertaken by the Office of the CEO. These actions exceeded his delegated authority and were ratified by the board after the fact. Another problematic area which really should have been avoided. Right, the next slide then deals with another area of focus, which is the Johannesburg Regional Office Building. Right, the former CEO of REF interfered in the procurement. This is the finding. We've investigated the process and so on. So we have found that the former CEO interfered in the procurement process in that he authorized the re-evaluation of the already evaluated bid by the BEC and BAC, Bid Evaluation Committee and the Bid Adjudication Committee. This was outside the normal procurement process. Another problematic intervention or interference. The REF SCM policy does not have a provision for that kind of a process. The assigned REF official failed to produce a due diligence report of the tender documents reviewing relating to her findings that led to the cancellation of the tender process. This would have been the official that sort of reevaluated the tender. Right, now based on the National Treasury Code of Conduct for Bid Adjudication Committees, the REF CEO does not have the power to cancel any tender, but rather to refer and to defer to the bid committees, bid adjudication and bid evaluation for reconsideration. Right, now we are of the view that by doing so, REF contravened the regulation of the PPPFA, in particular Regulation 13 subsection 2, by failing to publish the cancellation of the tender on the e-tender or the same manner it was advertised by the then CEO. These actions exceed his delegated authority and were ratified by the board after the fact. This after the fact ratification, it's really a governance failure on their part. Fundamentally, the conduct of the erstwhile REF CEO, together with that of the senior official, effectively overrides the decision of the BEC in a manner that contravenes established legal and regulatory frameworks. So there was a measure of management override, which is outside of the regulations. Right, you can go on. Page on, please. Right, page on. Right. Following the conclusion of its investigation into the panel, we issued, or the investigating team issued, right of reply as we presented before to all those members of REF that were pointed to by the evidence. Among these individuals are the executives and former board members. I was informed that this process is still underway. We are finalizing the evidence packs for disciplinary referrals, which will be submitted to the relevant authorities. We will, of course, ensure that even the executive authority is cited with all these referrals. The matter between the SIU and the former CEO as an implicated party, we also gave him the right of reply, and that process is still underway. At this stage, until we do the right of reply, complete the right of reply process, we cannot really confirm these adverse findings. Similarly, the former board members will also be afforded the opportunity to provide their right of reply, amongst others indicating the rationale for the various decisions that they've made, endorsements and approving, or the ratification that they've made after the fact, as well as for their failure to implement consequence management. You can proceed. Next slide. Right. Following the conclusion of our investigation into the Joburg office building, well, I think we've already covered this part. It's about the right of reply. Sorry for the repeat. Yeah, I think this part really is already covered. It's really more still about the right of reply. You can page on, please. The next slide, please. Right. We've also pronounced ourselves on the part of the terms of reference relating to recruitment, vetting, and appointment processes for senior officials. As we indicate, while the recruitment, vetting, and appointment do not fall within the scope of our investigations, we have made observations in this regard. We have received allegations that the Road Accident Fund appointed some REF executives without following the due employment process and without vetting the executives. Among the appointed executives, there is an executive who is alleged to have absconded while facing 12 counts of serious financial misconduct at the City of Johannesburg Metropolitan Municipality, which includes regiment's accounts. There are further allegations against executives and managers who were previously working with the erstwhile or former REF CEO, and that their employment at the REF did not follow the due employment process. The REF employee vetting process is either poor or not properly conducted. The instability brought about by the REF CEO, insofar as it relates to his organizational adaptations or organizational changes, led to Section 89, which read with Section 189 of the Labor Relations Act. I think this related to some of the retrenchments that were initiated there. Due to some of these employees being suspended and so on. So we have found that they either felt intimidated, and that resulted in really poor cooperation with the investigation of SIU by those employees. But of course, we kept on following through, and where necessary, we would use the SIU powers. Okay, you can slide on, please. Right. We've made some of these summaries for the honorable committee. The board oversight weaknesses. The board we are of the view that the board did not adequately exercise its fiduciary duties of care, skill, and diligence. And again, these are the standards applicable to the board of directors. And this would be applicable whether you're in private or in public sector entity. Critical decisions, including those with significant financial impact, were approved without robust interrogation of risks, compliance requirements, or long-term sustainability. Evidence suggests a tendency towards rubber stamping management proposals with limited accountability enforced. Now, with regard to governance structures, the governance committees, including Audit and Risk Committee, were either dysfunctional or lacked the independence and capacity to provide effective oversight. This is clear from what we have found as part of the governance failures. We are of the view that the reporting lines were weak or either weakened, resulting in inadequate escalation of audit findings, risk assessments, and control failures to the board. Finally, the governance failures at the REF created an enabling environment for maladministration, weak internal controls, and escalation of financial risk. Now, these systemic deficiencies, as we indicated before, compromised the Road Accident Fund's ability to deliver effectively on its mandate to compensate road accident victims. Right, you can proceed. The next slide deals with the aspects on the terms of reference relating to financial management and compliance. Right, next slide, please. Right, we are of the view in this case relating to compliance with PFMA and related financial prescripts, including allegations of irregular, fruitless, and wasteful expenditure. This we would have derived from various aspects of the investigation. The impact of foregoing of the use of panel of attorneys, for example. We've already mentioned that. And lack of representation caused the increase in default judgments. The total amount of default judgments issued against REF for cost and fees from 2018 and second quarter of 2023 amount to 4.7 billion plus. This is, as we indicate, this is cumulative. So this amount is very, very significant. It really demonstrates and represents significant management and board failure. Had it not been for this foregoing or the manner in which the panel was foregone or disestablished, REF would not have suffered this financial loss. The actions of REF contravenes Section 51. Section 51 particularly relates to the responsibilities, as the committee would be aware, of the board, the responsibilities of the board as the accounting authority. Amongst others, they failed to prevent irregular, fruitless, and wasteful expenditure. Amongst this default judgment lies claims which may have not warranted substantial settlement if defended. Right, now with regard to the corporate panel, payments made in terms of the corporate panel of attorneys, totaling 26.6 million, as we indicated before, exceeded the delegation of the REF accounting officer being the CEO. Furthermore, the expanded amount is above the total contract price of 10 million per annum. Now, an estimated amount of 141 million was an irregular payment since there was no approval of the board, no special operations in and information technology committee for the contract or extension thereof, when appointing corporate panel of attorneys. The amount of 66.1 million paid to date for the Johannesburg office building arises from a flawed procurement process and may, in fact, will constitute irregular expenditure. The SIU found that awarding of the claim backlog tender called Cienza, valued at about 713 million, with an actual spend of 317 million, was irregular due to non-compliance with Section 217 of the Constitution, Public Finance Management Act, and the Preferential Procurement Regulations. Next slide, please. Yeah, still under this focus area of the terms of reference, the sale and lease back arrangement, this related to the fleet tender, valued at 5.2 million for the transfer of 56 REF-owned vehicles, was found to be irregular in contravention of the Section 217 of the Constitution and Section 51 of the PFMA. There's also a cleaning contract for 4 REF offices for a period of 3 April to 2nd April for an amount of 12.1 million. There was a 6% escalation on original bid amount of 12.1 million. That resulted in a contract increasing from 12.1 million to about 13.5 million. Following the expiry of the original 5-year contract, valued at 13.5 million after variation, the REF awarded additional contracts to the service provider totaling 1.9 million. These were not subject to open competitive bidding, despite National Treasury instructions requiring open tender for procurement exceeding 1 million. The absence of documents confirming adherence to this requirement, combined with fragmented and overlapping short-term contracts, suggests serious non-compliance. This may undermine key principles of fairness, transparency, and cost-effectiveness referred to in Section 217 of the Constitution and Section 51 of the PFMA. Next slide, please. Next slide. Right. We also refer to the sub-human capital performance management licenses, which were procured by REF. And the finding is that these licenses are not being used. So this clearly is fruitless and wasteful expenditure, and the value is about 1.8 million. We have, in previous presentations, amongst others, presented on duplicate payments. And we referred to about 102 law firms, which includes the sheriffs, who received duplicate payments from REF of approximately 340 million. This, we are saying, as a result of REF poor record management and failure to conduct periodic reconciliations. There's also reference to blocked payments. We previously reported on the blocked payments to the value of 482 million for attorneys that were due for payment by reason of REF internal investigation. Now, in relation to the above amount, we noted that the matters marked by the REF Treasury as blocked due to the REF internal investigations were actually incorrect. There are instances where a law firm would be investigated by REF for bill of cost, and Ref Treasury would block all matters related to that law firm, which prejudiced the claimants. The blocked amounts are accumulating interest, which Ref will be liable for, and this may have implications on the financial statements. Next slide, please. Right. The blocked payment approach presents a misleading picture of liquidity within which Ref, whereas the interest accrued on such payments helps to increase the Ref funds' overall financial liabilities and may result in fruitless and wasteful expenditure. Now, following the conclusion of our investigation, we also issued the right of reply to persons involved, and of course, indicating that we intend making adverse findings. These individuals are executives of the Ref. Like we indicated before, we are finalizing evidence packs, which will be submitted to the relevant authorities. We've also made criminal referrals where the evidence of criminality is uncovered. As we indicate, we meet with NPA from time to time to follow through on these referrals. We've also referred evidence of misconduct against certain legal firms to the Legal Practice Council. We have met with the new board. This is the board that has been appointed recently in terms of its processes and related referrals, with a view to ensuring effective consequence management. We have also submitted systemic recommendations for the improvement of various deficient processes to the Ref acting CEO, outlining observations, identifying weaknesses in Ref internal controls, and proposing measures to strengthen those controls. Right, with regard to the cash flow management, you can slide on, please. Right, as we indicate, while this does not really fall within the scope, we have nonetheless made certain observations in this regard. Right, despite the establishment of the special court role for Ref default judgments on 26 April 2023 by the Deputy Judge President Sutherland for the Gauteng Johannesburg divisions, it is reported that the Ref cases have crippled the court roll, with trial dates being allocated for October 2029. And Judge President Mulambo, as he then was, remarking that hundreds of Ref summonses go unanswered. This is a problem. If matters go unanswered, it clearly means that there's a problem in the briefing patterns that lawyers really do not appear to answer. Adding to the dilemma in the fact that Ref paid 240 million in legal fees just for cases in the Pretoria High Court, whilst the two Gauteng High Courts dealt with 45% of all cases countrywide. Well, there's a reference to the publication there that we have looked at. We have established that as part of its current and as part of our ongoing investigation for the period covered in 2018-2023, the default judgments have ballooned despite the former CEO of Ref claiming that the primary purpose for the terminating the panel was to cap legal costs and to cut expenses. We noted that the matters marked by the Ref Treasury as blocked due to the Ref internal investigations we've already indicated these were incorrect. Instances have been reported to the SIU where law firms would be investigated by the Ref for a bill of costs dispute, whereafter the Ref Treasury will block them, as we indicate, thereby prejudicing the claimants. And we already indicated that the amounts are accumulating and Ref will will be liable for interest. There are claims that have been on the requested and not yet paid list for more than 300 days, which remain unpaid, whereas the other matters that would be paid after 120 days. The control and management of this not request and not yet paid list remains a challenge and creates room for manipulation and arbitrariness. Right, the lack of control and management of this RNYP has in some instances led to attorneys approaching the courts for writs being served on the ref, resulting in attachment of ref furniture and its bank account. In some instances, SIU was called upon to intervene and avoid the attachment of ref assets, but this instance is related to the list of duplicate payments being investigated by SIU. The ref has changed its bank account to avoid attachment, but this strategy is not sustainable and creates risk regarding the money flows for the ref. The lack of at least regular bank reconciliation by the ref is a major risk and creates opportunities for manipulation of funds. This averment is bolstered by the phenomenon of duplicate payments made that we reported on. The lack of bank reconciliation caused the ref to leave substantial amount with major banks unaccounted for. Right, now we are still on the observations on the cash flow. The ref invests funds in alternative accounts with the apparent intention of shielding these funds from legal attachments. However, these accounts are not subject to proper internal controls, and the interest earned on these funds is also not adequately monitored or recorded. The lack of oversight creates opportunities for financial manipulation and misstatement of ref's true cash flow and liquidity position. As we state, such practices may amount to financial misrepresentation and could be viewed as attempts to circumvent financial accountability and transparency. Furthermore, the absence of proper governance over these transactions undermines the integrity of ref financial management and may have broader implications for audit compliance and public trust. Right, we move over now to some of the matters, and this is the aspect in the terms of reference that focuses on alleged procurement irregularities and non-compliance with supply chain policies. Honorable Chair and honorable members, at the risk of not repeating, we've already spoken about the panel of attorneys. We've already spoken about the expenditure on Cienza. We've already covered the office building contract, the fleet contract, cleaning security, and subcontract. These are the matters where procurement irregularities have been found. As I indicated, we've already covered the Johannesburg office lease. The next slide, please. Next slide. Expenditure on Cienza, we've already presented. This is really just to ensure that this aspect of the terms of reference identifies matters under this aspect. We've already covered corporate panel of attorneys. The security services contracts, although we mentioned them, I think as we presented above, they probably didn't come out explicitly. There were security services contracts. The first one is Mposha Security Services. The original 5-year contract, valued at 13.3 million, escalated by 41.56% to 18.9 million. The evaluation process reflected serious inconsistencies, with bidders awarded full scores despite missing CVs and so on, inadequate experience, raising concerns over the integrity of the adjudication process. This is inconsistent with Section 217 of the Constitution. There's also Mjayeli Security Services, a 5.18 million contract for guarding and armed response services that was awarded. The irregularities included the concurrent operation of overlapping contracts, retroactive signing of service level agreement, and contract escalations that ultimately increased the value of the contract to 9.6 million, again in contravention of the SCMA, PFMA, and the Section 217 of the Constitution. We are in the process of preparing litigation-related documents for an application before the Special Tribunal to declare these procurement processes followed and subsequent appointment of the service providers invalid, and that will necessarily lead to the recovery of funds. Under the fleet contract, though we've covered it, but we just emphasizing here that REF is owed 5.2 million by a fleet service provider, which relates to 50 vehicles, which the ownership was transferred from REF to the service provider without any payments being made for the respective transfer of ownership. The vehicles are currently in possession of the said service provider. So this is really the finding that we've made. Now, in terms of duplicate claims, although we've covered this, we are saying in this case, the investigation focused on the losses incurred by REF caused by duplicate payments made to several firms of attorneys from 1 March 2021, which includes unlawful acts of appropriation. So this is really to expand on the duplicate payments that were allegedly effected by the sheriff, who executed upon the writ of execution and received funds on behalf of the instructing attorneys. The REF has a payment system which indicates that when a claim offer is accepted, whether by settlement or by way of a court order, such claim will await 180 days before it is paid. Now, as a result, the attorney would then attach a REF bank account by way of writ of execution served by the sheriff, causing the REF bank to effect payment in terms of the writ upon the lapse of 180 days. The same claim would be paid again, thus contributing to duplicate payment. We've already indicated the problematic area of these duplicate payments. We've already covered the area around the 102 law firms who received duplicate payments to the region of about 340 million. We approached this, when approached with evidence, some of these attorneys admitted, I think we've already presented before, and they would then sign what's called acknowledgement of debts, right? From the approximate 340 million, we have managed to recover some of the funds. To date, we have signed this acknowledgement of debts to the value of more than 70 million. And the actual cash recoveries to date is about more than 42 million. There's a figure of the previous report. Now, we have revealed that the total amount of 276 million was paid directly to the REF by the legal practitioners. Oh yes, when they were approached and so on, when they got to realize that we're investigating, they paid back directly. So we are investigating whether such instances were possible misappropriation of funds. Right. Now, Honorable Chair and Honorable Members, the following slides, again, we would have presented them before in terms of the status of the of the investigation. There's a detailed investigation. I really apologize that the slides keep moving while I'm still, on a specific slide. And perhaps at this stage, I'll ask either Mr. Lekgetho, who is in charge or who's overseeing the investigations, or Ms. Presibe, to really run through the rest of the slides. It's not a lot of really the current status of the investigations, high level. Mr. Lekgetho or Ms. Presibe, please take over. Thank you.
No, thanks, Advocate, and good morning to the chairperson and to the committee. In terms of the slides reflected here, it just shows the background to the RAF investigation, where it indicates that in terms of the Act, the objectives of the RAF is to pay compensation in accordance with the Act for loss or damage wrongly caused by the driving of motor vehicles. And the RAF is funded by way of a fuel levy in respect of all fuel sold in South Africa. The investigation ensued based on the affidavit dated 5 May 2021, provided by a RAF senior manager, forensic, as well as letter dated 5 March 2020 from the RAF to Legal Practice Council. Amongst other matters contained in the said affidavit was the issue of the duplicate payments, and as well as the matters relating to tender irregularities. Prior to the issuance of subsequent publication of the proclamation R44 of 2021, there were allegations referred to SIU, which upon evaluation were found to be within the mandate and accordingly investigated. The mandate of the proclamation, that is the proclamation R44 of 2021, it must read with the schedule. The schedule is normally attached to the proclamation, which provides for the investigation of the following matters, which is the serious maladministration in the affair of the RAF in respect of number one, compensation of payments made by RAF to claimants and claimants' agent, and also to look at the payments made by RAF to service provider in a manner that was contrary to applicable legislation, manual guidelines, practice notes, and National Treasury Act, and also the matters which were issued in a fraudulent or a corrupt manner, or any other related losses or irregular or fruitless and wasteful expenditure incurred by RAF or state, which resulted in irregular or proper or unlawful conduct by official employee of RAF or any other person or entity in relation to the matters which are mentioned above. Can go to the next. Then in terms of our process, normally once we get the proclamation, we do what we call the letter of engagement. The letter of engagement is just for us to engage the department that will be investigating so that they can know the terms of reference and what is it that is expected in terms of us. But in terms of this, we say SIU we used to enter into SLA, which is service level agreement. Then the court ruled that entering into SLA with the institution being investigated compromised the independence of SIU. Then the SIU therefore changed from the SLA and adopted a letter of engagement. I think the issue of SLA is because we enter into agreement. Then when you go to the letter of engagement, it's just one-sided. We just inform the department that this is what we're going to do, because we found that once we get into agreement, there's some negotiation that goes in, whereby now it tends to compromise the investigation. The SIU investigation outcome are communicated to the accounting officer or accounting authority through this letter of engagement. And the purpose of the letter of engagement is in the main to inform the management on the approach that will be followed by SIU to investigate the allegation as set out in the proclamation, and provide management with an indication of the cost estimate, resources in respect of the said investigation. The LOE is not part of the investigation methodology, whereby the LOE is signed by the SIU and sent to an accounting officer or accounting authority for acknowledgement of receipt. And the LOE indicates the nodal points, which indicate this is the person that will engage with in terms of looking for documents or anything that we looking forward for in terms of the both organization. You can go to the next slide. Then we also explain the right of reply, because during the presentation, advocate referred to right of reply in many instances. Then upon conclusion of our investigation, and in all circumstances, we afford the person affected by adverse finding a right of reply so that they can able to put on their version. And a right of reply is part of an investigation process whereupon the affected person is afforded an opportunity to address the SIU on its preliminary finding against such an individual. And as part of the investigation process, the SIU will, in all circumstances, afford a person of interest with the right of reply in respect of the finding to be made against him or her. The response received from the person is viewed in a serious light as instrumental for the SIU conclusive finding. Then in the REF investigation, the SIU noted with concern a directive which was issued by the REF to its employee in respect of the right of reply, wherein employees were directed to forward the SIU right of reply to the REF management. Such responses to the SIU as well as coordinated. And the directive is thus viewed by the SIU to have direct compromise to the investigation and may amount to interference, because when we do the right of reply, it's against an individual. No matter we've got the nodal point, but once we make the finding is against individual, and we expect an individual to respond to that right of reply, not to be a part of management, because once we do the referrals, it will be against an individual. A written correspondence was sent to the former CEO in regard to this. Then there's also non-cooperation with the investigation by REF nodal person. This is what we found based on the nodal person that we have mentioned in the LOE, that in the REF there was a person who was nominated to be a nodal point, and as a result, that person, we requested information from the person, and the person did not respond to the request that we have sent. And as we know that in terms of the SIU Act, failure to adhere to a lawful subpoena issued by the SIU amount to criminality. As a result, we end up going to a police station to open a criminal case against such an individual. And we are busy in contact with the investigating officer so that we can get the outcome of such cases. So there was some form of a non-compliance or non-cooperation by the nodal person on this regard. You can go to the next slide. Then in terms of the focus area of the investigation, as it has been outlined, we looked at the procurement and tender irregularity, where we are looking at the fruitless and wasteful expenditure. And we also look at the duplicate claims and payments made to attorney, with claimants and sheriff, and also look at the change of mandates. We also look at the payments made to service provider in terms of the REF Act or contract, and also invoice submitted to REF, including the bills of costs. And we also look at the fraudulent claims in terms of the focus area of the investigation. So this is what we have investigated. And what has been outlined is in terms of the mandate of the inquiry, But in terms of the full update of the investigation, particularly on the matters which are not focus of the committee, we do have update to such matters. That is all from me, Chair. I'll hand over back to Advocate Matibi. Thank you.
No, thank you, Mr. Lekgetho. Honorable Chair and honorable members, that concludes our presentation. Thank you very much for the time given.
Thank you very much, Advocate Matibi, and thank you, Mr. Lekgetho. I wanted to ask you before we take a break and return with the questions. There were instances during your presentation where you said perhaps Mr. Lekgetho and his colleague could provide more detail. Can we give them an opportunity to do that?
No, thank you. Thank you very much, Honorable Chair. And Mr. Lekgetho would be able to do those, starting with the value of the 90%. Mr. Lekgetho, you would have those notes as we were preparing yesterday evening.
Yes, yes.
Please update the Honorable Committee.
Yes. No, thanks, Advocate, and thanks, Honorable Chair. In terms of the one matter where we indicated that in terms of the corporate legal...
Sorry, before we start, Mr. Lekgetho, can I ask that we... Sorry.
Honorable Chair. Can I proceed?
Sorry, Mr. Lekgetho, we can see on the screen.
Yeah. Can I proceed, Chair?
No, can you stop the screen? Yes, but I was asking that you stop sharing the slide on the screen so that we can see you properly.
Okay. I will try and show myself, Chair. I'm traveling, so I'm not at the office. Let me try and yes, I am traveling. So apology for that I'm not wearing formal, but in terms of answering the question, the first one was the 90% where the attorney, where the RAF utilized the GEPF, the panel of attorney, and out of it, we indicated that one of the law firm was given 90% of work, and the value of that 90% of work amount to 164 million in terms of the matters that were referred to that particular law firm. Then the other one, in terms of the cancellation of panels of attorney, whereby it has caused some form of default judgment to RAF, then the amount that we have calculated at the time was 4.7 billion. But this was 4.7 billion in terms of paid default judgment, meaning that there might be other default judgments which were not paid. But based on the one that we have calculated, which were paid, it's 4.7 billion. I think those are the matters that I needed to respond on, Chair. Thank you.
Thank you very much, Mr. Lekgetho. Can I ask which law firm was that? I mean, there's no allegation of impropriety. It's just the allocation on their part. It's just the allocation of work, as I understand. Are you able to name the law firm? Because we've previously received a spreadsheet of law firms in committee on the record. And I think we need to establish whether it's one of those or it's a new one.
No, thank you for that question, Chair. Mr. Lekgetho, if you don't have the law firm on hand, when we answer questions, Honorable Chair, we should get the name of the law firm. Shouldn't be a problem because it's a factual finding that we made in terms of failure to rotate the law firms, and there's this one that was given 90% work. We should find the name, or there's the hand of Mr. Sibe, perhaps you want to help us with the name of the law firm. Mr. Sibe, over to you.
Thank you, Advocate. Good morning, Chairperson and honorable members of SCOPA, HAU, and colleagues. The name of the firm is Malachi and Malachi Incorporated. That's correct, Chair.
Yes. Thank you. Thank you, Honorable Chair. That's the law firm that was granted such immense amount of work. Thank you.
Thanks, Recruitment. Another clarification question. Can you describe the process that should be followed in the cancellation of a tender? Or because there was the slide, I think it related to the list. Are you not able to hear me?
Yeah, Chair, the connection was a bit problematic. We can hear you now.
The connection is not good. Can you hear me? Okay, I've just tried to change to another one. Thank you so much, Advocate Martin, and I'm sorry. Now, I was asking that, could you or one of your colleagues describe the process that should be followed? Yes, when the accounting officer or the board or somebody is unhappy with the outcome of a tender.
Yeah. Excellent. I think we got the question. Mr. Sibe or Mr. Masego, if you can just take the Honorable Chair and Honorable Members through what is required to be followed in terms of the ref policy or any other applicable legislation on what process to be followed, because we have said in one instance the CEO cancelled the tender, and I think we said the ref policy doesn't allow that. Can you please take the committee through? Thank you.
Oh, thank you so much, Honorable Chairperson and HOU, Mbuso Masego here. So the process as dictated by the preferential procurement as well as the RAF policies is that whenever there is a tender that is issued, there will be a BEC that will look into the matter, and there will be a BAC that is chaired by the CFO, and the CFO will be responsible to appoint the members of the BEC as well as those of the BAC, with the CFO being the chairperson. So once the tender, depending on the delegation of authorities, it will go into the BEC for evaluation, for a BAC to adjudicate on the tender, and then it will go into the office of the CEO so that it can be given to the opposite committee, which is the committee of the board, and subsequently be given to the board for the board in order for it to take the decision on the tender or to approve the service provider which has been recommended as a successful bidder. The similar process in the cancellation ought to have been followed in that regard. So if the matter did not find an expression into the board, it means where the board has the delegated authority, then the matter will fall short of complying with the procurement as well as the RAF procurement policies. Thank you.
Okay, thank you, Chair.
Thank you very much. So those are my clarification questions. Can I propose that we take a 15-minute break? It is 10:20. Shall we please return at 11:25?
Thank you. Thank you, Chair.
Thank you.
Recording stopped. Recording in progress.
Welcome back, honorable members. I'm just checking that the team from the SIU is back.
We are back, Honorable Chair. Thank you.
Thank you. I hope I won't have connectivity problems. It's I think I live in an area that resembles my village, but here in the city of Cape Town. I would have thought things are better. Let me give an opportunity to the members to ask questions of the SIU. We will take 3 members at a time. So I see Honorable Beasley, Honorable Neil May, and Honorable Non-Danger. So let's take those 3 for now. your questions directed at the SIU. So Honorable Beasley, you go first, and then I won't interrupt. So once you're done, Honorable Beasley, just indicate so, and then Honorable Neil May will come through and indicate when you're done, and then Honorable Nondenja, so that we can get through the questions seamlessly. Thank you.
Thank you, Chair. So my first question goes to, at what stage, or if at any, has the SIU submitted interim findings to either the Presidency or to the Department of Transport? And the reason why I ask this is there's clearly been a lack of governance, and it's actually blows my mind that the board has been able to continue as long as they have. They appeared before Scopa once, and straight away it was the most shambolic meeting I've ever attended to in my life. And I immediately wrote to the Minister of Department and Transport and saying, you've got to fire this board. So I just want to know if any interim reports have been made about the lack of governance in the Road Accident Fund, and if so, when were these interim reports released? Because it's actually pointless having interim reports if they don't get acted on, and it's clearly been a complete lack of governance, and it's been surprised that they were allowed to continue for so long. Then in terms of the panel of attorneys, why was the GEPF approached? There's so many different state institutions. Why particularly the GEPF, and why didn't they just go for a normal tender approach? So any thoughts on that? And then it was mentioned that one of the panel of attorneys has been paying one of the executors monies past ways. Do we know the quantum and also the executive concerned? And maybe if it is under investigation, we can't say the actual executive, but do we know the quantum? And then in terms of duplicate payments, I know there was a rough recon, but do we know how much has actually been repaid, or is it still up in the air at the moment? And then a point I made earlier when the SIU did the report is just the lack of bank reconciliations. I mean, that goes to the first thing in internal controls and auditing we get taught is the importance of doing bank recons. So it's actually bizarre that an organization like the RAF actually doesn't do bank recons, daily bank recons. And then this is a question, and I don't know if Honourable Atkinson's in this meeting, but if he was, he would certainly be asking this question, is alternative bank accounts. I mean, is there a risk, or has the SIU identified any bank accounts that actually aren't linked to the accounting system? So they run separate to the accounting systems. And is there a risk that there are potential bank accounts out there that are totally unlinked to the actual system? And then who actually issued the directive for staff to forward the SIU right of reply to the RAF management? And Rich was the executive. And then a question I should probably know the answer to, but I don't. So that's why I'm asking it. Who is the actual accounting officer at the RAF? And then the second last question, is there any process for preservation orders or to attach assets? And if so, how far are we in the process? And then if you don't mind, I've just got a question that somebody from the public has sent. So I'm just going to forward that on. The RAF clearly has serious panel of attorneys available, yet they failed to instruct them to defend them in the court against the tsunami of default judgments. And why is that? And in your view, would you agree that had they utilized the available attorneys coupled with a fully functional internal settlement hub, the damage caused to the RAF would have been substantially less? Thank you, Chair.
Good morning, Chair. And please appreciate that I'm on the farm in the Eastern Cape. So if you don't mind, I'm not going to put my camera on. Good morning, Chair, and to Advocate Mtibi. and to your team and my colleagues present. The questions that I have is some of them have been asked by Honourable Beasley. The ones that I wanted to home in on is, did the SIU look into the specific transactions of the leases? When we had the presentation from National Treasury, there were quite a few lease agreements, and they were all for the office lease for state attorneys. And my question would be, why
Honourable Nel-May?
would RAF be responsible for paying for state attorney? Yes, can you hear me? Can you hear me?
Just repeat the question, please. Why would, and then you got cut off there.
Thank you so much. Chair, obviously we looked at, they procured attorneys, and that was in the presentation by the SIU. We saw that there was a procurement of attorneys. Now, those same corporate attorneys were then seconded to the state attorney's office. Okay. Now, when we look at the lease agreement and we look at all the deviations for the top 20 suppliers that we were given by National Treasury, there are numerous amounts, numerous lease agreements that RAF is paying for, and they amount to quite a large amount of money. Office lease for state attorneys Cape Town, and it goes on for Durban, and it goes on for the different areas. Did the SIU look into those, and why do you think why would the RAF actually be then procuring premises for the state attorney to fight to answer their cases? The second question that I have is the transversal agreements, which were actually asked by Honourable Beasley, but I wanted to only 4 of those law firms that were specified in your presentation earlier were seconded to the state attorney's office. So then that obviously that transversal agreement is not compliant. The other question is regarding the sheriffs of the court. How many sheriffs were found to have received double payments? And did those sheriffs voluntarily come forward, or did they only respond after being approached by the SIU? Chair, I also received 2 messages from the...
Sorry, Honourable Nel-May, I just want to be sure on your last, before you proceed, on your last, are you referring to sheriffs, or are you referring to attorneys? Because a sheriff...
it says there, and sheriffs. So I wanted clarity.
I see. Okay.
Who were they? It said they sheriffs and attorneys. Okay.
Okay. No, thanks for that. Yes.
Then the other question, there were 2 questions that were given to me that said, with the CEO and board clearly acting irrational in as far as the panel of attorneys are concerned, could the same not be said about the implementation of the legal accounting standards, which is IPSAS 42 and the legal board notice 271 of 2022? Now, I do know that Advocate did mention that obviously the board was non-compliant. And then the last question is, it has been proven in court that the non-payment of deserving foreigners and medical aid supported claims are flawed in administration, and the law should this issue not be added to the investigation? Thank you, Chair.
Thank you, Chair. Good morning, Chairperson and everyone. Thank you to SIU for this comprehensive presentation, which will assist us a great deal in doing our work. I've got a few questions for SIU. My questions are mostly for REF. I would like to know whether was REF supposed to use all 19 law firms? And also to say, did the board ratify the contract that was extended 4 times without approval? You are saying RAF board through its chairperson ratified. I would like to know where were the other board members, and was this before or after the 4 years extension? Based on the preliminary findings in respect of a family relative who was paid by a law firm and the executive, what's the progress on the matter? Were there any cases that were opened? And if yes, who were the people that were charged? Was it the board? Was it the CEO, or who was charged, if there were any charges? And yeah, I think I will pause there, Chairperson. Most of them are covered by my colleagues. Thank you.
Thank you very much, Honorable Nadenja. Over to you, Advocate Motibi. I don't know if you can comment on the accounting standard, but yeah, because it falls outside your investigation.
That's right. No, indeed, Chair. Although it falls outside, just from the floor now, really, having observed and really followed the conflicting situation between the AG and the REF. In fact, my view to the team, because that was so significant. My view to the team was that we should, if it's not covered by the proclamation, we should then seek a process to include it in scope, because it represents such a significant administration area. And I was preliminarily of the view that it really requires attention, because having followed the proceedings of SCOPA, where SIU was also present, where this matter was presented, the preliminary view was that although they say they've got the rights to take up, matters legally and so on, as far as I was concerned, given that there's a name of the board that's responsible for this, the Treasury, the internal auditors, and so on, pointed, even the Auditor General pointed in one direction. It was only REF that had a different view, So for me, that created an issue that we needed to scope it in, but we have not really gotten to a stage where we have scoped it in yet. But that would be my view on the audit standard. It's really a concern, and it requires really to be interrogated extensively. Honorable Chair, we'll go to the beginning of the questions. At what stage have we submitted the interim report? I just did a quick check with my colleagues. We did submit the interim report, and they will come up now with the date. They'll inform the committee of the date on which we submitted the interim report to the President. So, in terms of the legislation we submitted to the President, I am not aware that the executive authority ever requested the copy of the report. But invariably, and this is with the recent times, that the President does release these reports to the executive authorities. So, in a sense, all the findings that were made in the preliminary report, and Honorable Beasley is right. The purpose of submitting interim or progress reports is to ensure that matters that are found at that time, if there are findings at that time, they need to be acted on. Well, the other consideration is none of the areas that we would have included in the progress report as findings would not have been reported to the REF itself if there are any kind of referral. So we would expect that they would have acted on the findings that we had made at the time. Right. So I'm assuming that my colleagues also took down the questions without repeating them. So why did they approach the GEPF? Do we know the quantum that was paid by the attorney to the relative and so on? So I'm going to hand this over to Ms. Kresibe. Honorable Chair, just an apology on behalf of Mr. Lakheto. As he indicated, he's traveling. He has had to leave the meeting because the shuttle was picking him up at 10:30, as he informed me. But we are all qualified here to respond to the questions. Ms. Kresibe is the Chief National Investigating Officer. She's almost overseeing the investigation. Ms. Kresibe, over to you, please, with the rest of the questions.
Thank you, HOU. Thanks, Chairperson. Just in response to the date of the report, we reported to the President the last report that we submitted was on the 15th of April last year. And we subsequently met with the Executive Authority where we presented our matters to them, but that was not the report as the HOU has indicated. However, we presented our preliminary findings to the Executive Authority and then the accounting office.
Through you, Chair, I'm not sure if I'm the only one. So, Mr. Siva, if you can just draw closer to the machine so that you are closer to the microphone, please. You're sounding a bit far. Thank you.
Sorry, am I audible now, Chairperson?
Yes, thank you.
Thank you so much, HOU. As I was saying, HOU, we have the date of the last report that we submitted to the President was on the 15th of April last year. And then the other one is currently being prepared. We're just waiting for then these final phases of our right of reply so that at least we submit a comprehensive report with findings. Then other than that, we have presented to then the Executive Authority as well as then the accounting officer being the acting DG of transport on all our preliminary findings on these matters. And then the latest one was then the presentation that we made to then the newly appointed board of RAF. Then on the issues of GEPF and then the panel, Chair, I think this one, it's allowed in terms of the National Treasury Regulation 16, capital A 16. So it's 16, capital A 6.6. Yes. That's the regulation for any entity to piggyback on a transversal contract that is awarded by another entity. However, there are certain steps that must be followed before this process is undertaken. They must ensure that the procurement process was above board, and they must also request all the documents relating to the appointment of then the service providers. So the information in respect of this one by GEPF was submitted to RAF CEO, and they then satisfied themselves in terms of the procurement process followed by GEPF. However, in terms of then the appointment The GPF had 19 firms that they had on their panel. However, they referred only 14 to RAF, and then RAF then appointed then 13 out of them the ones that were submitted by GPF. In terms of then the duplicate payments, I will then hand over to my colleagues, Mr. Mbuso Maseko, to take us through then the responses.
Okay.
Thank you, Chairperson.
Thank you so much, HOU and the Chairperson. Honorable Member, this is Mbuso Maseko. I will address the first question which was raised by Honorable Beasley on the issue of the family members that have received funds from the law firm. At this juncture, I think for the protection of the investigation, what we can report on to the honorable members is that there is a family trust that is involved in the process, and there are monies that are being paid. So as to the quantum is still the subject of the investigation, but there are those monies that will range to the 74,000 rand that will go to the family members that are coming from that particular law firm. So the issue of the family trust, where also the executive of the RAF is party to that family trust, is a subject of investigation. So with the permission of the Chairperson, I wouldn't want to divulge much insofar as it relates to that trust. The other question that was raised by Honorable Bailey is around the issue of the alternative bank account. We have reported previously, and which we do again today, honorable members, that there are investment accounts which we are looking into, where there are monies that are paid into different investment accounts, and the controls thereof in terms of those investment accounts. It's a subject of concern to the SIU in terms of the correct accountability of the monies that are invested and the interest that is derived thereof. There are also other alternative bank account which the matter is currently before, it has been referred for criminality and for the protection on the integrity of that criminal, because we have indicated in our presentation that we are from time to time meeting with the NPA. The matter is at an advanced stage where there were monies that were siphoned into those accounts. So I would report in so far as that is concerned. There is an issue or the matter that also Honorable Beasley raised on the default judgment, which is coming from the public member who's asking on whether should the RAF utilize that. Insofar as I can respond to that with the assistance of the HOU, that will be mainly the issue within the purview of the administration of the RAF, as opposed to it being the subject of our investigation. The other question that was raised by Honorable May relates to the issue of how many sheriffs receive duplicate payments. So the sheriffs, by virtue of their mandate, they are the messengers of the court. They serve documents on behalf of the attorneys. So it is straight law that they will receive the payments on behalf of the attorneys. More so since we have reported that the court that are mainly dealing with the matters of RAF will be the Pretoria courts, given the jurisdiction. So we have engaged with the Sheriff of Pretoria East and the various sheriffs in the Pretoria, whom have received a duplicate payment, but we could not have, or we did not find any wrongdoing from their end, as those monies were directly transferred into the attorneys responsible. We also engaged because RAF at the time also had a jurisdiction in the Johannesburg Central. We did also speak to the sheriffs in that area, and again, there hasn't been any adverse findings that were made. So suffice to say that the duplicate payments will be squarely on the attorneys that we have alluded to in our presentation. Moving on into the use of the state attorney, I think from that side, from that end, we did indicate that at a time when the decision was taken that there will be a utilization of the state attorneys, there were numerous challenges that were there, ranging from the right of appearance and the appearing in the court for one matter at a time. We did indicate in our slide, and that there hasn't been a sufficient or adequate representation and a plan that was put in place in order to ensure that there is a seamless process when the RAF had to forego the use of the panel of attorneys. The other question came from Honorable Nontenja, where she has been asking about the issue of the ratification. The ratification, as we have indicated, it was a post effect. And in fact, as we are seated here with the investigation work that has been done, the ratification was not done for the purposes of correcting the procurement process, but rather to ensure that it is compliant with the audit. And this is the process that was initiated by the procurement department when they had to, for a lack of a better word, had to legitimize the process of the ratification. The Honorable Nontenja also asked, why are we referring to the board chair as opposed to other board members? We are referring that because the signature appended on the resolution is that of the chairperson, but the overall, it's obviously the board, the entire board that is involved under the care of the board chairperson. So we were careful in terms of packaging that, hence the reference to the board chairperson. On the issue of charging, we did indicate to Honorable Nontenja that we have made the referrals and we are meeting from time to time with the NPA, and also we are busy now facilitating or dealing with the evidence pack insofar as it relates to the disciplinary referrals and also any criminal activities that may flow from the issue of the bank accounts. I think I have covered everything, Honorable Chair. Is there one that I'm missing? Oh, the process of attaching assets.
Yes.
Yes. The process of attaching assets will be triggered by there is a judgment that was issued by Judge Person on the 180 days within which the RAF will have to pay the claimants that the claims which they have adjudicated on. So the attorneys would normally go for the writs before that time, where they will attach the bank account. And if those monies are not paid or there isn't sufficient money to cover for that, then they will opt to go for the attachment of the furniture. And that will trigger the process now of instructing the sheriff to be the one undertaking that process of attachment of those particular assets. I'm not sure if that was the question. The issue of the SIU litigation, we've got the special tribunal that is says with looking at the matters of the SIU, and we've got the litigation or the CLU, Civil Litigation Unit, which also touches on the issues of the process of the preservation when the investigation team provides the evidence that warrants the application of the preservation order. Thank you so much, Chairperson.
No, thank you, Chair. Honorable Chair and honorable members, I'll try to note some of the questions that we may not have covered. Honorable Nontenja asked, was REF supposed to use all the 19 law firms? So as my colleagues indicated, this was what's colloquially called piggybacking, which is provided for in the PFMA and SCM regulations. It's got its own rules and regulations attaching to that. If REF approached GEPF to use their panel, they are not necessarily obliged to use all 19. They can use any number of the firms that are on the panel, subject to the correct process being followed to piggyback. So in this case, it looks like only 13 law firms were so almost contracted to be used by REF. And then the other one from or the accounting standard, I think we from Honorable Nilme, I think we attended to, we responded to that. So, Mr. Maseko, there's a question from Honorable Nilme. Which law firms were seconded to the state attorney? Did the REF second any law firms to the state attorney? Perhaps if you can note that. And then, if I understood it correctly from Honorable Beasley, amongst others, he asked if are there any preservation orders that we have made from our side so far. Please indicate that through, of course, through the special tribunal or any other preservation order. Payment by the executive family, I think you responded to that. Yeah. Honorable Chair, I think those may have been the ones that on my notes we may have missed.
Yeah.
Okay. On the other one from Honorable Beasley, who is the accounting officer? I think this one I can respond to. Look, I think we probably use the word accounting officer, accounting authority interchangeably, and we must start using them correctly in terms of the PFMA. PFMA refers to the accounting officer or accounting authority. An accounting authority is in relation to a state entity, which is like REF, which is a scheduled entity, and it has the accounting authority. I think the word accounting officer was used relatively, and we should actually refer to the executive officer, the CEO, the chief executive officer. So on that one, I think it's just the naming of the chief executive officer. But in law, in terms of the PFMA, the accounting authority in terms of Section 51 is the board. Mr. Maseko, can you please come in on those, or Mr. Sibe, on those ones that I've noted, please?
No, thank you so much, HOU and honorable members, and my apologies for omitting the response. On the issue of the secondment, it's not the law firms that are seconded, but the attorneys that are seconded into the state attorney. On the issue of the leases, yes, there is the transactions that we are looking into insofar as it relates to the Johannesburg office. So there are specific transactions that we are looking into in terms of the money flow.
Okay. preservation orders?
The preservation orders, as I have alluded earlier, and this is the matter that we are guided by the CLU. So we have prepared the information, or rather in the process of providing the file to the CLU in order to get the proper legal guidance as to how we proceed in that front. Thank you.
Maybe just to expand on that last comment. Honorable Chair, I don't want to assume that honorable members knows some of the acronyms. How it happens is that the investigations or the investigating officers would identify areas where we need to implement preservation for assets and so on. And they will then hand over to our civil litigation unit. That's the acronym CLU that it stands for. And then the civil litigation unit will then go through the documentation submitted by the investigators so that they are satisfied that there is a legal basis for preservation. And then they will then proceed to take it to the special tribunal. So we can assume then that there will be preservations that are conducted once the civil litigation unit has looked at that, and how we do this really, because time is of the essence. The preservation orders should be done quickly, and that is why they are done in the I think the term used is ex parte, and ex parte is really, it really means that we as a party approach the special tribunal without even notifying the other party, and then we get to present and we get the orders to preserve, just so that we don't alert them. We don't alert them, and then so that they can dissipate the assets. But to respond to the question from my colleague, what he's saying, there are some preservations that we are considering. Thank you, Honorable Chair. I'm not sure if we would have missed any question. Thank you very much.
Chair, I have a follow-up.
Thank you very much, Advocate Matibi. Honorable Nibble May, you've got a follow-up.
Yes, Chair. Chair, my follow-up is back to the State Attorney's Office, because if you look at the constitutional mandate of the State Attorney's Office, and they obviously handle civil and criminal litigation, okay? The use of the State Attorney's Office is what I was actually checking. If an advocate could say, constitutionally, was RAF supposed to or can use the State Attorney's Office? When you consider that, given that the State Attorney's Office being used to handle RAF claims, which are ordinarily civil matters between the fund and private claimants, so that was the one area that I was trying to look at. The other area was, under what authority or agreement did the Department of Justice, did they approve that arrangement, with regards to that? Because the mandate of the State Attorney's Office is slightly different to what RAF has intended using the State Attorney's Office. And I wanted some clarity in the sense of, was it actually the State Attorney's mandate to defend the RAF against claimants? Thank you.
Thank you very much, Honorable Nelmay. Let me give an opportunity to Honorable Atkinson and then Honorable Isak, and then you can take those questions together, Advocate Matibi and your colleagues.
Thank you very much, Chair, and thank you very much to the SIU for a very comprehensive presentation. Chair, I'd just like to ask of the SIU some basic questions of law here, or of, I suppose, procedure here. And that is right at the beginning, they were mentioning issues around, I think, lease contracts and other things that the then CEO basically did that exceeded his authority, and then later got condoning by the board. I'm asking, is it even legal for the board to condone stuff like that? So if someone does something that is actually not within the bounds of their authority, or in fact even, I guess, the board's authority, because if they're overriding issues from that, the board that got to decide on the leases, he had no power whatsoever to interfere with that, and I'm not sure if the board had as well. So could the board even condone some of the things that they have condoned? I mean, did they not exceed their authorities as well? And then the second question comes up where you mentioned the fact that that the proper vetting wasn't done on a lot of the employees, and that some of them might have actually been basically irregularly appointed. And specifically, the issue comes up with the lack of security clearances that all the senior officials are meant to get. So does that not then mean that ab initio, his decisions on the changes in the accounting principles by which the road accident fund was being measured, and also the legal board notice and the legal new RAF1 form, whether those just don't actually fall away because they were basically put in place by someone who actually wasn't even properly legally appointed. The next question I wanted to ask you was whether there's been any investigation into the Bokomiso project at all, the ICT project. And then you also mentioned about the Cienza project, and I think this was even prior to CEO Letswalo, it was during Dr. Eugene Watson's term. So my question to you is, how far back does your investigation go? Does it include work of the board prior to this one that has just been taken down? So in other words, the board that was in place between 2016 and 2019, because it would appear that the Cienza project was initiated then. And the question is whether the present, or whether the immediately past CEO Letswalo, whether he was involved at all in that Cienza project. And then when you were looking at the default judgments, at the amounts of default judgments, whether you were able to categorize whether they came from ones that had been rejected by the RAF, because I think we had a presentation done to us earlier this week where it was indicated that nearly 77% of all the claims that arrived at the RAF were rejected because they didn't meet the requirements of that illegal board notice, and I think only about 27% were dealt with. The default judgments, how many of them actually come from that 77% that weren't even considered by the Road Accident Fund? And how many came from the group that actually complied with their board notice? Then the other question I wanted to ask was, sorry, just got them lined up here. Just bear with me a moment. I think I got this, I think, from probably one of the internal RAF staff members, but I just want to know whether you actually are receiving reports from internal staff members, whether those are being considered by you. And then I think in a previous iteration of the Road Accident Fund, we're talking very much about the concerns about the fact that they got rid of the panel of attorneys that would have defended the RAF against default judgments or, in court dealings. And obviously that was a very reckless move because it cost over 4.5 billion in default judgments against the fund. But whether or not one would consider that possibly a better situation was in earlier days, 25 years ago, and in earlier days where matters actually didn't often go to court, where there was a settlement hub within the Road Accident Fund, and matters were settled within the Road Accident Fund. So I think what they endeavored to do was to make sure that as few matters as possible ever went to court. So it obviously gave the Road Accident Fund a lot more control over the amounts of money paid out to people because they were settled within the RAF themselves. Whether that actually wouldn't have been a better issue than even having a panel of attorneys, and possibly cheaper for the Road Accident Fund as well. And then Honourable Beasley was quite correct. I do have the interest in those bank accounts. And you mentioned about the bank accounts that were probably used unlawfully to hold amounts of money that, for one reason or another, the Road Accident Fund felt it necessary to basically hide away from the public, which, as you correctly say, would create a distorted view of the actual financial position. Would you be able to give us any indication as to the amounts of money that are involved there, whether you've been privy to those bank accounts and how much are in them? And also a question I asked the other day, there was a report in the newspapers about 3 or 4 years ago about so-called illegal or I suppose unauthorized bank accounts that were being held at Investec Bank on behalf of the RAF, whether these are the accounts in question or whether that is something entirely different as well. And I'm just trying to think, I think there's one more. No, I think I've covered everything. Thank you very much.
Thank you. So before you come in, Honorable Isaka, I've just counted the number of questions, and I think perhaps at this point you should give Advocate Mutibi and his team a chance to answer so that none fall between the cracks. Otherwise, there will be too many. And then I'll come to you, Honorable Isaka and Honorable Bila.
All right. Thank you, Honorable Chair. So I'm hoping my colleagues would have made notes of that. But just the first question around the CEO exceeding his authority, that, as we indicated, indicates it is an irregularity. It's contrary to the governance process, contrary to the delegation of authority. So ratifying it after the fact does not correct the irregularity of it. Is contrary to good governance. So really, I think the board should have taken steps in order to ensure that that there was consequence management, or some action should have been taken for the CEO to have exceeded his mandate. And we will certainly pronounce ourselves in the report to that extent. Right. With regard to the recruitment, and I'm sure my colleagues can also come in. We did indicate that although they were not sort of covered, but we made pronouncements. If those people were appointed without being vetted or integrity checks been conducted, they would possibly have been appointed by REF. So we are pointing that, firstly, this one that was appointed from the city of Johannesburg, if proper due diligence and checks were done, they would probably not have appointed him. And we're really pointing out that there was a failure in that regard on the part of REF with regard to its recruitment process. There are those that we are indicating that most of them were appointed by the CEO, either they used to work with him before and so on. That is just a risk indicator on its own. There really needs to be some deep dive into that on whether the proper procurement processes were followed. But I think the real question is the decisions taken by those people would they sort of say be binding on the part of REF? I mean, if they are appointed and they are deemed to be REF employees, and they act within their delegated authorities, those decisions would be authorized or would be binding on REF. Now, irrespective of the poor process of the recruitment process. So if REF did not do a vetting process on the person that comes from City of Joburg, and as at the time of this finding he was still the employee, then that the employment contract would be valid as at that time. Usually, some of the state institutions would say you are appointed subject to being vetted, and that in itself, it doesn't make the appointment of the employee irregular. It's just that, ideally the vetting process should be done before the appointment, so that when you appoint the person, you know that you are appointing a fit and proper person. So in this case, the recruitment process was done, but the vetting and the integrity check were not done. Right. And then, my colleagues can indicate whether the ICT project and Cienza, and how far back are the investigations. So, Ms. Kasiba, you can come in and take the questions from there.
Thank you, HOU. Mr. Maseko will take the questions.
Thank you so much, CNIO, and thank you, HOU and honorable members. On the issue of Cienza, the honorable member Atkinson is correct. It was prior to the time of the then CEO of the Road Accident Fund, and I think the question that arises from there is whether it is a matter that is within the purview of the SIU. Yes, because there were payments that were made in respect of that contract that are covered within the period of our proclamation, because without running a risk of interpreting the proclamation, but I will just point to the members that the proclamation also had some certain caveats that will speak to the matters that are ancillary and which are connected to the matters in which we are looking into. There was a matter that was raised also on the default judgments. The default judgments on their own, they become a consequence to a decision that has been taken to forego the panel of attorneys. So this is the amount that is quoted of 4.7 billion is a consequence of that. And the 4.7 billion, as the COO indicated, that it is only the amount in respect of what has been paid. The figure will definitely be more, as we have written to the Road Accident Fund in terms of our powers, so that we can be provided with the accurate amount that will also cover the amounts that are not paid, which came in as a result or arises as a result of the default judgment. The default judgment on their own as to how they arise on whether or not the RAF was supposed or was not supposed to defend the matter will find expression in the focus area that deals with the fraudulent claims, because in the process or the focus area of the fraudulent claim, that is where we are looking into the entire value chain of the claims, right from the lodgement. We're looking at the repudiation, we're looking at all the matters, including those that would attract the default judgment. So we are still going to look into that when it comes to that focus area. There is an issue that has been raised on the alternative account, where the honorable member asked on whether or not does that involve the Investec accounts. The answer to that is a yes. We are also considering those accounts which are with the Investec. The comment that has been made on the alternative system that can be used, whether it will be the mediation when it comes to the processing of the claims, I take it that will be a discussion that will find expression in the administration of the RAF, as we are unable to pronounce on that insofar as the investigation is concerned. I think I have covered that, and then there's an issue of that was raised by Honorable May as a follow-up question on the issue of the state attorney mandate or the legality that arises thereon. I would ask the head of the unit to kindly assist when it comes to the follow-up of that question. But suffice to say that the Solicitor General, when we did the investigation, there was no signature that was appended by the Solicitor General that will legitimize the process of using that. In terms of whether that in a legal sense is the state attorney mandated to deal with such, that will be a legal question that I would leave for the head of the unit to assist me. Thank you so much.
No, thank you. Thank you, Honorable Chair. So if I go back to Honorable Atkinson's questions with regard to the period, Mr. Maseko related, and he was almost quoting from the proclamation, that the proclamation has a specific period, but it does provide for us to look at prior incidents that happened outside of the specific period, as long as those matters are related to what we are investigating. So we will, therefore, from the Sienza and the other, if they happened, even if they happened beyond the former CEO's time or the former board's time, we will look at them and we will pronounce on which board was in place at the time, and if we need to act on that, on the members of that previous board, we will do so. So the period legally we are allowed to look at the prior period. Well, my colleague said, the issue around whether he's probably correct, is for REF, and probably out of the inquiry, whether REF should really, introduce, a step before the litigation, whether it involves alternative dispute resolution and so on. It's a practice that's applicable in various state institutions, such as the South African Revenue Service, and the point I'm making, it's an acceptable practice that they could include a step that involves, alternative dispute resolution before the litigation. That will go a long way in reducing the litigation costs. And then, yeah, the bank account used unlawfully to hold amounts. I think Mr. Maseko, Honorable Atkinson asked if we have the amounts. Do we have the amounts in those accounts? You have confirmed the one relating to Investec, but do we have the amounts related to those other accounts? Right. With the question, yeah, just put an asterisk on that, and then please come back to it on the amounts if we do have. Honorable Neil May, the use of the state attorney by state institutions. By law, the state attorney can actually be used by any state institution. Even as SIU, we do use state attorney. However, and I will talk just as a scenario, as an example, we have experienced a lot of inefficiency or ineffectiveness on the part of the state attorney, right? And we have engaged them. We have engaged the Department of Justice, and so they are aware of our cry. So we then sought to create a SIU panel of attorneys, which is permissible, right? So in the case of REF, as a state institution, they can use the services of the state attorney. But as my colleague indicates, there is a process, of course, that you follow and so on. And as you have seen from the investigations, that they have also opted to create a panel before, but that panel was disestablished, you know. So we have pronounced ourselves that the manner in which the panel was disestablished, done away with, was irrational, and it has caused losses to REF, right? So I thought I would respond to that question in that way. Okay, Mr. Masego, do you have the amounts in the bank accounts?
Thank you, HOU. The amounts that we are referring to, I will put them on an average because they range from 1 million up to 100 million, where they will come in as a deposit and then there will be transfers that will be made in those accounts. Thank you.
All right. No, thank you. Thank you very much. Okay, Honorable Chair, I think those were the questions that we needed to cover. Thank you very much.
Thank you very much, Advocate Motibi. May I give an opportunity to Honorable Isaac and Honorable Bila?
Thank you. Thank you so much for the opportunity, Chairperson. Good morning, Team SIU, our colleagues online. Chairperson, I'm trying to figure out where to start because so much has been said and lots has been covered in terms of the presentation. I will try very hard to be as concise as I possibly can. I think, you know, for the benefit of South Africans, Chairperson and colleagues, when I looked at the presentation yesterday, slide 21, obviously, you know, is in essence summing up for South Africans in a broader spectrum in terms of what really has been transpiring at the Road Accident Fund. So just in two bold paragraphs, I salute the advocate and his team for having just you know, captured the synopsis of the crisis at the RAF. But be that as it may, the issue on the ICT projects I see has been covered. The security issue was spoken to and covered. The issue regarding trust, the sheriffs, Honorable Beasley covered me, and one other issue, the Johannesburg office was covered. And then I want to just talk to some salient slides. For example, if I might, I want to speak to the vehicles in specific, which is alluded to in slide 24, and I'll couple that with slide 39. Now, there were the sale of vehicles transfer for the sum of about 5.2 million rand, which was alluded to in slide 24. And if you couple that with slide 39, they were sold to the fleet service provider or handed over. What I wanted to try and find out is, one, who is this service provider that the vehicles were handed back to? Number two, based on that, is there an idea where are these vehicles? Who is driving them? Who is using them? Are they just stored in some storeroom, store yard, losing value? Have they been stripped? I don't know. But, on that issue of 5.2 million rand worth of vehicles that were just handed back and not paid for back to RAF, I'd like to maybe just hear if somebody can say something more about that. And then I need to educate myself, Chairperson. On slide 25, I note that they speak there of, if I can just find it, there we go. The top line, the top bullet, the RAF procured SAP human capital performance management licenses, which the RAF is not using, for some 1.8 million rand, thus amounting to fruitless and wasteful expenditure. Perhaps somebody could just enlighten me on this human capital performance management license for 1.8 million. So I just wanted to touch on that one. And then, Chairperson, with your permission, so I'm sorry, I'm just moving between the slides, but it's just how the questions have flowed based on what other colleagues have spoken to. So on slide 31, we speak to the lack of the bank reconciliation accounts. Now, in any business or in any institution, it's just my common, simple understanding that you have people employed that are being paid a salary, that medical aids are being paid for, pension funds are being paid for, and obviously then being responsible for certain basic work that they do between 8 and 5 or 9 and 4, whatever their working hours might be. But in terms of bank accounts that are not being reconciled or that were never reconciled, Advocate Ntimi just alluded before he went off to the issue of vetting and process and people that were employed, etc. Covered that quite well. So the quality that this points to on slide 31, the quality of employees, Chairperson, and this is perhaps just for us as the committee to consider when we hopefully put our report together, is that we should be seriously calling for a complete performance assessment across the board of the entire staff complement here that seem to be derelict and not doing basic stuff like reconciling bank accounts, which is not a rocket science thing if you're capable and in that position. So I wanted to just highlight that regarding that the performance assessments need to be conducted across the board, whether staff are fit for purpose or not. Then I wanted to also comment on the change of bank accounts, which was just alluded to also in an earlier discussion. If I might ask, these change of bank accounts where monies were transferred, surely that had to come with board approval, where you close the one account and you transfer or open a new account to protect the money. If I can just find out, was board approval given by members of the board to action that one? And then, Chairperson, I think I'm covered. Most of the other stuff has been answered very, very comprehensively. Again, I thank you for the opportunity. Thank you.
Thank you very much, Honorable Isaac. Over to you, Honorable Bila.
Thank you so much, Chairperson, and good morning to everyone. I think I have two questions to ask. The first one is on executive vetting and conduct. Based on the recent precautionary special leave of the RF CEO and previous concerns raised against unvetted senior executives, in some instances, you find that people who are being investigated can interfere with the investigations. So I just want to check with SIU investigation if they have uncovered evidence of individual in RAF, executive management, or the board members who are deliberately obstructing or interfering with the investigation? If yes, what specific referrals for misconduct or criminal charges have been made against these individuals? The second question is on vulnerability to fraud. It has been indicated that the system that enabled the 340 million duplicate payments, as reported, involved attorneys explored the 180-day processing period. So I just want to check, has the SIU investigation determined if this specific vulnerability has been permanently addressed by the REF? And how is the SIU monitoring the REF's revised payment protocol to prevent the emergence of new schemes? Thank you, Chairperson.
Thank you very much, Honorable Bila. And over to you, Advocate.
Thank you, Honorable Chair. I will start with the questions raised by Honorable Bila. The people who are investigated can interfere. We have actually come across that scenario, and specifically the former CEO, where we had issued a correspondence to members of the Road Accident Fund that were identified by the investigation. We had issued letters to them giving them the right of reply after some findings were made against them. And the investigation team informed me that they have established that the members of REF were being informed that their rights of reply have to via the CEO's office before they can be presented to the SIU. We found that unacceptable, and we raised it with the board, and we also raised it with the CEO himself. So that's one scenario that we came across. And the other one is where the contact person, we use the word nodal, the nodal person for the investigation, the liaison person, was just not cooperating with the investigation. And that person is quite senior. And that's where we even had to open a criminal case against that person. So those are instances where we have experienced interference with our investigation. I'd like my colleagues to then make note of responding to the issue around the fraud vulnerability, whether the issue around the 180 days has been addressed, and whether we monitoring it or not. Please, Mr. Maseko or Mr. Sibe, please make a note of that. Right, now, if I go to Mr. Honorable Isaac, apologies, who is the service provider whose vehicles have been handed to? So my colleagues, please make a note of that if you have an answer. And the SAP human capital or human resource system, I mean, my colleagues can add on this, but this would be the module in SAP that is used for human resource business, the human resource processes. So the SAP would probably have sold, or they would have procured those licenses to use SAP for purposes of human resource processes, but our investigation is that those licenses were never used, which is problematic. Okay, and then change of bank accounts. Yeah, on the change of bank accounts, it is tried. It is tried law in state institutions that the change of bank accounts is approved by the accounting authority or the accounting officer, as the case may be. So in this case, it would have to be authorized by the board. Okay, the vetting and the quality of people, we can't really agree with you more, Honorable Isaac. It does appear that, you know, there are really question marks in terms of the quality of people at REF, in particular in this question in the financial management department, because honestly, as you say, conducting financial reconciliations is expected of any financial division to do, but we do support the call one way or another to do, and you know, either a skills audit or suitability audit, you know, of employees at REF. So Mr. Siwe or Mr. Maseko, can you please come in on the questions that I've left to you? The 180 days, do you have an answer? And then who the vehicles were handed to?
Thank you so much, HOU and honorable members. On the issue of the service provider, I don't know, with the permission of the HOU on whether or not we can divulge the name.
Yeah.
The name of
sorry,
the service.
sorry, with your permission, Chair, I'm sorry that I just crept in. My colleague, Mr. Maseko, of course, you're a lead investigator as well, but I'm of the view that it won't prejudice the investigation if you name the service provider. I mean, it is a fact that they would have, you know, either outsourced or handed over the fleet to a certain service provider. So you can name the service provider.
Thank you so much. Thank you so much, HOU. The name of the service provider is Fleet Data. And the vehicles, you would note in the first slide where we do the introduction of the contract that we are looking into, we are referring to 56 vehicles. And at the end, we speak of 50 vehicles, meaning that there are 6 vehicles that have been written off because the Honorable Isaac was asking on whether the value of these vehicles have depreciated. Yes, indeed, they have depreciated, because the argument advanced at this juncture is that from the service provider, the vehicles are now worth over 2.5 million as opposed to the amount. So still there hasn't been any payment that has been effected in that regard. On the issue of the SEP, the HOU has clarified in that there is no points that one would add. And on the issue of the change of bank account, I think the HOU has also indicated, but there is also one issue that one might add, that in the midst of changing the bank account, there is also monies that where the bank account will be attached by the attorneys on the writs of execution that they will serve into the bank and subsequently to RAF. There are monies that are in the suspense account to the value of 15 million that were uncovered by the investigation, and those matters are in the process of being recovered on behalf of the Road Accident Fund. The issue of the payment process, we have sent out our systemic recommendation insofar as it relates to the reconciliation and the processes that has to be followed. On the question on whether the system is still vulnerable to fraud, yes, indeed, it is, because in one of the matters that we have touched on, that we indicated that there are criminal referrals that were made. There were monies that left the road accident fund and were placed into the various individual, and that matter is before the police. And in speaking of the value of that, we are talking about the money to the tune of 30 million rand. So the system remains vulnerable in that front. And also there is a recent judgment that also seek to speak to the issue of RAF having to pay the claimants on the 180 days. That judgment is being studied by our legals, and we will look into it on how it affects the system as of the RAF. Thank you so much.
Thank you, Honorable Chair. I just looked at my notes, how I've noted the questions. It doesn't look like there's anyone outstanding, but we are subject to the Honorable Chair and the Honorable members. Thank you.
Thank you very much, Advocate Motibi. I just have a few questions of my own. The first one is a request. Could you please send to us the 14 law, in fact, send us the 19 law firms of the GEPF that were on the GEPF panel, and then indicate the 14 that the Road Accident Fund subsequently contracted with. So that's a request. If you could furnish us with that,
yes,
be most grateful.
Okay.
The second is a question. Has your team made an assessment of what the claim attorney ratio became when the state attorney took over? In other words, how many claims were there versus the number of attorneys? Have you made an assessment of that? If not, simply then the number of state attorneys active on road accident fund cases would suffice. I don't know if any of your colleagues know now. If they don't, then you can send it in writing. Yeah. But let me wait. Yes. Let me wait and hear if maybe they've looked at that.
Okay.
Yeah, they can answer if you guys know.
Thank you. Thank you, Honorable Chair. Firstly, the request, we will act on the request, and we will send the requested information. On the assessment of the attorney ratio, how many state attorneys, my colleagues, if you have done that already, please indicate. If not, we can then send the information also in writing. Let me hand over to Mr. Sibe or Mr. Masego.
Thank you so much, HOU. On the assessment of the claims per se, that has not been done by the investigation, but on the number of the state attorneys at the time of our review, which will be last year, there were about 62 that were responsible countrywide.
Okay, so then we can, Honorable Chair, we can probably do that exercise of the 62 attorneys, at least as at the time of the finding of the number and the ratio of the claims. We can do that exercise and submit it when we submit the requested law firms. Thank you.
Thank you, Advocate Motibi. May I ask, in slide 15, on the governance failures, still relating to the corporate panel of attorneys, the last bullet point says that the board chairperson, through its chairperson, approved the ratification and extension of the contract for 6 months. In the interviews held with the officials, the ratification was for their internal process in case of audit, not to ratify the procurement process. Was the board chairperson aware that this was being done post facto for the purposes of the audit, or was he or she under the impression that permission was still being genuinely sought? Did you have opportunity to speak to them?
No, thank you. Thank you, Honorable Chair. I will allow my colleagues to come in. Mr. Masego.
Thank you so much, HOU. From the information that has been gathered by the investigation, the board chair was in fact aware on what has been done. And from the issue of the ratification, as I have indicated, that it was because of her signature in the minutes, but it is a matter that involves all the board members that have taken that ratification. So this is mentioned where we are saying we spoke to the officials. We are referring to the key officials that were centered around the process, which will include those in the procurement and also those that were in the legal space at the time.
Thank you very much. May I also ask, there was a point where you referred to the impact of the Section 89 together with Section 189 of the Labor Relations Act and its impact on the level of cooperation with the investigation. May I ask if you remember, were any of the, in fact, let me just ask, was that because the people were placed on suspension or were made redundant or similar? Which one was it? Section 189, I think, refers to retrenchment either for operational or for financial reasons. I am not certain off the top of my head what Section 89 is for. So will you just explain Section 89 for us? And then I will ask my next question. I just want to know the meaning of either section.
Yeah. Thank you, Chair. I'll allow my colleagues to come in, but I can at least immediately respond because I know it offhand. You're right. Section 189 of the Labor Relations Act deals with processes that would lead to retrenchments. The other section, I'll allow my colleagues to come in. I take it that it's probably a section of a different legislation. Mr. Masego, can you come in? And please explain the nature of the impact, how that scenario impacted on the investigation.
Okay, no, thank you so much, HOU. When we were referring to that, the slide that the chairperson has directed us to, it was in relation to some of the officials which may have been suspended, and that we subsequently conducted interviews with them, because in the ordinary course of business, we would, when we interview an individual, request that they depose to an affidavit so that the matter can find expression into our report. So what we have identified is that there are certain individuals who will come and appear before the SIU, provide the information, and when they have to depose to an affidavit, they will cite the fact that their matters are still before the CCMA. Others will indicate that they are before the Labour Court, and for that reasons, they wouldn't want to agitate the process in such that they will be flagged when they are to provide us with the affidavit confirming the information that they would have otherwise provided to the investigation team.
Thank you.
You
Thank
have
you
not
very much.
covered the reference to the other section. 189.
189.
I think we've clarified. The other one, I think it's 89. I'm trying to look at it. The other section, please.
Okay.
If you can't, Advocate Lebopa is there. Works with you. I must probably indicate.
All right. So if I may come in, HOU.
Yes.
Then 289 of the Labor Relations Act refers to then the disclosure of information. These people were suspended, and they raised issues relating to certain prohibitions that were imposed as part of, or maybe as the conditions of their suspension, in terms of releasing certain information to the SIU. That's the reference to Section 89. Thanks.
Okay, so Honorable Chair, it looks like it's both sections are of the same legislation, focusing on disclosure of information and retrenchment process. And I think my colleague has indicated how it has impacted on the investigations. Thank you.
Thank you, Advocate, and thanks, colleagues. So am I correct, therefore, in my understanding, that as a condition of their suspension or some other process, the Road Accident Fund instructed them not to reveal information to the SIU or anybody else? That seems to be then the outcome.
Okay, Mr. Maseko or Mr. Sibe, can you please respond?
Thank you so much, HOU and the Honorable Chairperson. What we are indicating is the issues that were cited by the persons within which we were interviewing, and we have not been privy to any directive that has been issued or their letters of suspension in that regard. Suffice to say that it is what they've indicated when we engage with them through our interview processes.
Okay, so if I understand, they then said, if I reveal the information to you as a statutory body established by this parliament, they might then get into trouble in terms of their suspension.
That's correct.
All right. Did you inquire about this with the Road Accident Fund? Because I am assuming that an accounting office and accounting authority has a responsibility to instruct their employees, active or suspended, to cooperate with the SIU or the NPA or the police and so on.
Thank you so much, Chairperson. We found ourselves in a position where the very same inquiry will lead to those particular individuals whom they would have been cited by those that we are interviewing.
So you mean in other words, so let me just understand that. Can you say that differently so that I understand it?
If I am to put it differently, it's that the very same person that we were to report that we are finding a non-cooperation with the person whom we are interviewing, that they are not providing us with the affidavit, the very same affidavit would have implicated the very same person that we were going to report into.
Okay. Okay, let's stay on this here. I'm assuming, so can you explain who your chief liaison person would be at the Road Accident Fund? Because I would assume that ultimately you have access to the chief executive or the board in the event that you are not getting cooperation. Are you talking about middle managers here, or are you talking about the chief executive officer or the chairperson of the board?
The nodal point, as the HOU has indicated, is a senior person who is in the executive. But when we conduct the interviews, we will liaise directly with the person whom we intend on interviewing without going through the nodal point.
No, I appreciate that. Then you speak to the employee, and the employee indicates that they are constrained. I am afraid worse consequences will happen. Who do you then speak to next in terms of the escalation of the you're escalating the obstacle now? So who's next? Just walk us through that process. I want to establish whether you received cooperation or obstruction from the executive or the board. Because they might come here and say, oh, we would have done something about it had they told us. So I just want to know, how high up did you escalate the information? Or you were constrained because those very same people were implicated?
I will answer that, Chairperson, in twofold, and I will give an example of the procurement process. The procurement process, as I have alluded to earlier, that will have the BAC that are appointed by the CFO, and then the matter will go into the office of the CEO, and it will go to the committee of the board, being the opposite, and subsequently it will land into the board itself. So if one is party to, for instance, in the BAC, and that person is constrained of not providing us with the information for a fear of victimization, that process ultimately, or by implication, will then mean that the board itself will have to account, the office of the CEO itself will have to account. So in terms of the escalation, one would find that there will be those challenges that will find expression in terms of the constraints, as we have alluded to in our presentation.
So I know you are being careful, but you need to assist us. Did you raise this matter with the chief executive of the Road Accident Fund at the time? Let me just
if I can come in. I see my colleagues is a bit struggling there. If I recall well, and we can confirm that to the Honorable Committee in writing, we did have a meeting at some point with the chief executive officer and some of his executives, and at that meeting, if I recall well, we did raise issues around lack of cooperation by the nodal person and others. And if I recall, he did sort of have given undertaking that he will ensure that there's cooperation. So we can go back to our records and say, when did we meet with him? And then post that meeting, did we experience any lack of cooperation or not? So that's the one escalation point, which we did. Now, my instruction to the investigators, including this team, and the Chief National Investigating Officer, Mr. Sibe, and the COO are the immediate executives. My instruction is, we should not behave as though we do not have the powers to subpoena and get the information that we require, right? Whether you are on suspension or whether you are on any other process, if we require information from you, we will firstly, of course, approach you and say, we need this information and. But if we don't get the cooperation, we do have the legal recourse, which our teams are beginning to implement at the moment. But I know that the question still stands. We will go back, Chair, and just check. We did raise it at one meeting, if I recall, and then we will confirm afterwards whether there had been any lack of cooperation and whether there had been any escalations or not after that.
Thanks, Advocate. There was somewhere where you said that you eventually had to lay a charge.
Yes,
Somebody was not cooperating.
yes.
Was that a person on suspension, or was that an executive at the Road Accident Fund?
That was the executive at the Road Accident Fund. And if I recall, that point came up at the meeting that we had with the CEO. And there was almost like an act or a push for us to withdraw the criminal case, which we resisted, and the criminal case was left standing. Hopefully, it's been progressed now. But the person is an executive at the Road Accident Fund.
All right. Thanks, Advocate. You did receive a case number.
Yes, we did, and we can provide it to the Honorable Committee when we submit the other information.
Please do. Is the executive concerned still at the Road Accident Fund?
Okay, Mr. Maseko, that you can confirm, please.
Yes, I
the
can
nodal
confirm.
person.
Thank you, HOU. Yes, I can confirm that the executive is still at the Road Accident Fund.
Still at the Road Accident Fund. So in other words, the police investigation going, the executive has refused to cooperate, and they are still actively employed at the Road Accident Fund. Was this escalated to? So was the chief executive therefore aware that this executive was not cooperating?
Yes.
Yes, Chairperson.
Yes, Chairperson.
Okay. Was the board made aware?
Yes, Chairperson, and there is a correspondence in that regard which also bears the case number.
Yes.
Okay. Thank you very much. If you are not constrained by your legislation and your regulation, we would really appreciate getting a copy of that correspondence where you raise issues, because we are going to have the board appearing before the committee to account for the level of fiduciary responsibility they exercised at the Road Accident Fund, and this is one of these. May I ask, and let me be transparent why I'm asking. We will next week have a witness who falls, I believe, within the category of employees you describe, who were afraid to provide testimony. They were suspended. This employee was central to the decision to some of the decisions regarding the panel of attorneys and the GEPF and so on. Let me ask, and the members will receive that statement in due course in preparation for that. Was this employee who was in supply chain one of the people who had difficulty as a result of a suspension in cooperating with you?
Okay, Mr. Masego, please.
If you don't know, you don't remember, fine. But if you can recall, please do.
So the question, Chairperson, is a person within the procurement.
Yes. So the person was a supply chain manager. That person was involved in the decisions regarding the panel of attorneys, and that person. So let me put it to you this way: the submission of the person to this committee, the statement I'm saying we will share in due course in the next in less than 24 hours with the committee, is that the person fearing that the Road Accident Fund would have matters undefended in court, and that the Road Accident Fund would incur losses within the rules. Basically this person either recommended or extended the term of the panel of attorneys so that the Road Accident Fund would continue to be able to defend claims against it. That employee was suspended for a very long period of time. So that's why I'm asking. And that employee will appear before the committee next week as we examine the matters that you have traversed with people that have got first-hand knowledge. So what I'm asking is whether this employee or people similarly situated were unable to cooperate with you as a result of their uncertain status in the organization because they are suspended.
Is it muted? Oh, yeah, yes, Chairperson, we did come across the employees of that nature. And we can confirm that subsequently to that, in other employees, as we have indicated, that there are other officials that we have interviewed, there are those that now are cooperating.
All right. Thank you very much. May I ask, you say the right of reply by the Chief Executive Officer, the former Chief Executive Officer of the Road Accident Fund, is still has not been concluded. Can you tell the committee when you began this process, what attempts you have made to make sure that the Chief Executive has a right of reply, and what his responses have been to those attempts to give him an opportunity to respond to your preliminary findings pertaining to him?
Yeah. No, thank you, Chair. So my colleagues, Chair, with your permission, I think it just spells out a process and some of the dates. I'm not sure if my colleagues will have them now.
That's correct. That's all I need. Yeah.
Yeah, we can. Oh, I see. If colleagues, if you have those dates, you're able to. If not, we can provide them as part of the response. Mr. Maseko, do you?
But you can also narrate you can also narrate in general terms and say, look, we began on this month. These are the attempts made. This is what happened. It's now been X number of months since, and this is where we are finding an obstacle.
Okay. Mr. Maseko or Mr. Sibe, if you're able to outline the process and the period.
Thank you, HOU. We will confirm the exact period, but from the speaking from the general term as the chairperson has requested us, we started with the interview as we have indicated that in terms of our processes, we would first engage the office of the CEO, because in particular, we are referring to the office of the CEO. At first, we struggled sometime in June last year in securing an appointment with the then CEO. And then we subsequently got an appointment in or around November. We will confirm the exact date. And flowing from that, as we have indicated that after an interview is conducted, we will transcribe the recording and then reduce that into an affidavit, which will be the facts that will be put under oath. We did not get the affidavit in as far as that is concerned, which necessitated that the SIU invoke the section 5(2)(b) and (c), which is a subpoena process. And that subpoena process is the process that is currently underway. We will provide the date in which we have issued the first subpoena, and we will also indicate to the committee with the exact date of the sittings of that particular subpoena or the inquiry process.
So thank you. I just want to confirm, you said you began when, in June or July 2024?
Yes.
And you only secured an appointment in November 2024?
Yes.
What reasons were given for the chief executive's unavailability for what appears to be 5 months at least?
We have the correspondences between ourselves and the PA of the chief executive officer, but over and above that, there were also at some point where there was an indication from the PA that she did not see our correspondence, but we will provide all that information through the head of the unit. But the reasons were not advanced to us directly by the then CEO on the unavailability.
All right, thank you very much. Will you please provide us with the name of the personal assistant or the executive assistant, the person you were corresponding with? Please provide that to the committee. May I ask the committee staff to take note that we need to ask that person to deposit a statement, a sworn statement with the committee, telling us the reasons that she advanced with the SIU for failing to arrange an appointment between the SIU and the chief executive for so long. May I ask, since then, have you had any opportunity at all to actually meet with the former chief executive of the Road Accident Fund since June last year, in pursuance of this objective to give him a right of reply? You mentioned a transcript and an affidavit. Am I correct in assuming that you met and there was a recording made, and that out of that recording and subsequent transcript, there would then be an affidavit?
Yes, Chairperson, we have met the former CEO on a number of occasions through our internal processes, the 5-2C hearing. However, we have not been able to start with the process of dealing with the merits of the matters that are under investigation due to certain legal aspects that he is raising, which RAF is currently assisting him with, one being the representation that he has requested, and also requesting access to documentation from the RAF. Thank you, Chair.
Thanks. Am I to assume that these are meetings now that took place since his suspension and subsequent termination of his employment? Did you get to meet him prior to his suspension and termination?
Yes, Chairperson, I think our initial meeting was prior his suspension. And then because our session was chaired by a senior counsel, then that he then contested, and then he said because our session was chaired by the senior counsel, he also requested that he be afforded legal representation of that stature. Hence, then the matter was then postponed. Then after
was the senior counsel representing? Sorry.
Then subsequent to that, then he was placed under suspension.
Was the senior counsel in question representing the Special Investigating Unit? Were they acting on your behalf?
Yes, Chairperson. This was in terms of our investigative processes, Chair.
Is that
sorry, through you, Chair?
Yes.
Just to clarify that aspect.
Yes.
This process, when you're subpoenaed in terms of our law, there's a interview or I don't want to use the word interrogation, but there's an interview that goes on, and there's a format that interview takes, right? There's a format that it takes, the format of a hearing, and it can be chaired by, any delegated SIU employee, right? In certain instances, depending on the complexity and so on, we do in-source legal practitioners from outside. Yeah, we outsource, but effectively, we appoint them, and I would delegate them as though they are SIU employee to to chair the hearing. So they would have a formal delegation where they chair the hearing, and then you will have SIU presenting, and he will be presenting, and it's quite an elaborate process. So my information is that at one of the hearings, or the first hearing, that's where he said, now if this person chairing the hearing is an SC, senior counsel, I would also require to appoint a senior counsel. That's the scenario. That's the scenario. So in that format, the senior counsel would chair the hearing, and the SIU would have either one of its investigators or lawyers presenting, and so on. So the one who presented the SIU case, and correct me if I'm wrong, Mr. Siva, was not an SC, right? It's one of our members. But then he was saying, if the chairperson of the hearing is an SC, he also requires an SC. So those are the kind of issues that we faced, and then it was postponed, and so on.
So, sorry, if I may add, he also contested then the appearance of the attorney, being then the issues around his view on some of the attorneys that are appointed in the RAF matters.
Okay, without going into detail, I mean, is this related to the chairperson? Yeah, if I recall, amongst others, apparently he did say the senior counsel that was chairing also appeared in one of the ref cases and so on. So that was
some litigation involving the road accident fund at some point.
Yes. So then for that point, he wanted that person to be recused, to recuse herself.
Okay. Thank you. So since then, as I understand you, you've made several attempts to reconvene that meeting. What happens at such meetings? What is the purpose of those meetings? Is it when there have been allegations and averments made against a person, as well as evidence, that you want to give them an opportunity to provide their own version of the same?
Yes.
Is that the purpose of the interaction? So what you are telling us that that still has not taken place in what would be over a year, correct? In substance.
That is correct, Chair. In terms of the purpose of the hearing, would be, in a sense, to give them the opportunity to put their version forward before we finalize our findings, right? So, Mr. Siva, perhaps you can indicate, in terms of timeline, when was this sitting where he objected and wanted the chair to recuse, and has there been subsequent sittings after that?
Thank you, HOU. We had, okay, there was an interview that was held in November last year. That interview, was what then we requested an affidavit, but then there were issues around it. Then the first hearing that we had was around June 2025. And that one, then that's when he objected to then the chairperson. And then that was postponed for 2 weeks. And then the second session, then there were issues around him not being afforded then that the counsel by RAF, and then his legal representative then requested that we intervene by writing to RAF and requesting them to provide him with the representation and the status of a senior counsel, and also request that he be given access to documents. Then that was also again postponed to another session, which then was then the last session that we had with him, which then was postponed, Senior Dear, because we were worried that without then the assistance that we were requesting from RAF in terms of this access to documents that he was requesting, as well as then the representation in terms of their processes and the policies. So the sessions were just delayed. So RAF now has come on board. They have assisted him. I believe that they will be assisting him with the legal representation, as well as then he has been afforded access to the records, and then we will be reconvening soon, Chair. Thank you.
So let me understand. So in other words, the Road Accident Fund will be paying for his legal representation.
That chairperson.
What do you mean assistance? I'm just trying to understand what assistance means.
We cannot confirm that, Chair, but all that we had to do was to request them to assist the investigation, which they've now they've written back to us indicating that they are assisting in terms of these processes. We are not sure whether they will be paying or would be. Thanks.
Yeah. We will ask them. We will ask them how they are assisting. Don't worry about that. So we will ask them to set out how they are assisting.
Through you, Chair, if I can
go ahead.
If I can contribute just on one aspect, amongst others, and I saw the correspondence, he's got his own attorneys, and whether RAF is paying for that or not, we're not aware. But amongst others, when the session where he objected to the chair was postponed, and we had to reschedule, amongst others, he was raising now this issue. I think he was still on suspension. He was saying RAF doesn't have access to his laptop, right? And then therefore he can't access the information that he requires to prepare, right? And ultimately, that's when RAF came back and said, no, he is not telling the truth. They have not denied him access to the laptop. Okay. Well, I don't know other areas where they are assisting the investigation. So that has since been settled, and now that's what my colleague is saying. We are looking to reconvene the hearing now. Yeah.
All right. No, thank you very much, Advocate. Please keep us appraised of whether that process does complete.
Yes.
One of the final questions from you make an observation that the governance committees, including the audit and risk committees, were either dysfunctional or lacked the independence and capacity to provide effective oversight. Can we be given a expansion on what leads to that conclusion?
I'll allow my colleague to come in, Mr. Masego or Mr. Sibe.
Slide 21.
No, thank you so much, Chairperson. I think what would lead to that, it is because if one looks at the matter pertaining to the Johannesburg office, you look at the matter which pertains to the GEPF, all those matters are riddled with the ratification, whereas there are certain committees that will need to play an oversight when it comes to that. And the board that is supposed to be overseeing these processes as opposed to the ratification that will be conducted. So that coupled with the issues of the panel of attorneys, as we have alluded to on the issue of the board that had to play an oversight, that leads to that particular conclusion.
Okay, so in other words, so what you're finding is that were they completely unaware, or they were aware but wouldn't ask the questions that had they asked, the transgression would not have occurred.
That's correct, Chairperson, and also that's why we are alluding to the fact of the consequence management that ought to have been taken by the board. If there is a ratification, as the HOE has alluded to, it does not necessarily correct the processes which have been undertaken. So in the lack of the consequence management, which is a matter that is under the duties and care of the board, they ought to have taken some consequence management or show that they have exercised their fiduciary duties.
No, thank you very much. The executive whose relatives or entities in the form of the family trust received monies from a firm of attorneys or firms of attorneys, has that executive been given an opportunity to respond to your observation?
At this juncture, we have not, Chairperson, and for the reason that we do not want to call an executive where we are just going to be asking about 2 transactions when there are 11 transactions. So from the accounting perspective, immediately when we are given with all the completeness of the transaction review, then that's when we are going to confront that executive with all the transactions, and it will be a once-off interview that will cover all the aspects.
I see. Okay. All right. May we go to the... I just want us to clear the matter of there are 2 linked issues here. The first relates to the duplicate payments. Now, I will relay back to you my understanding of how some, if not all, the duplicate payments occur, or if not most, sorry, the duplicate payments occur. That the Road Accident Fund has been granted an extension of the statutory, I think it's 120-day or 90-day, I cannot remember, but it's now it has to meet its financial obligation to pay a claimant within 180 days, which is 6 months. So the way I understood you to be saying is that the attorney, fearing that the Road Accident Fund will not pay upon the expiry of that 180-day period. And I see that some of the payments are past 300 days. In fact, they told us that there are claims that are outstanding for years and years when they were here. So what some attorneys do is to attach the bank account so that they can get paid upon the expiry of they obtain a writ so that it can be executed from day 181. Is that correct? That they do this preemptively so that once the 180 days expires, then the payment is enforced out of the Road Accident Fund's bank account. Is that how it works?
How it works, Chairperson, is that once the claim is settled and the RAF is due to pay for that particular claim, the claim will be in the requested not yet paid list, which will wait for 180 days in order for it to be paid.
Right.
So the attorneys will not wait for that 180 days. They will then go to the courts and apply for a writ of execution in fulfillment of the claim which the RAF has already agreed to. Then they would attach the bank account and be paid for those monies that are that is due to the attorneys. So because the RAF does not conduct the bank reconciliation, when the 180 days comes and they pay, the RAF does not check on whether there was a bit of execution that was done on the claim, but they just release the payment. Then they will realize subsequently after that there is duplicate payment.
All right. No, thank you. Look, I mean, I think you've then dealt with my second question, and one of the things we will deal with next week relates to a brief to a media company, a tender issued to tell the public that the road accident fund pays in 120 days. So what you are saying in the evidence that you have seen, the road accident fund pays in 180 days, which is 6 months. So in other words, a request will be made but settled in at the expiry of the 180 days.
That's correct.
Okay. Now, thank you. We will canvass this with the road accident fund, because my understanding of the 180 days was due to the backlog, and I did not understand it to mean that even if they have the money, they must nonetheless wait for 180 days just because those days are available to them. Do you know? So, in other words, during that 180 days, the claim does not accumulate interest. Do you know, or whether it does?
In the judgments that will be given at some point, there will be a moral rate that will be applicable. So there will be those that will accumulate interest, and there will be interest that will be paid.
All right. No, thank you very much. I think I am just checking my screen to be certain that I've asked all the questions. Oh, I promise I will finish shortly. Those security contracts in slide number 38. So one of the aspects that this inquiry is looking into is the provision of security upgrades in excess of what a RAF policy provided. So I just want to ask, were any of those companies, Porsche Security Services or Mjaeli Security Services, providing close protection services? Or was it just for physical security, to the best of your knowledge?
Mr. Maseko, please, if you can't confirm it, please indicate so that we can clearly indicate.
If you can't confirm, just say.
Yeah.
No obligation. We can ask them.
Yeah. No. Sorry, Chairperson. I didn't want to confuse the two security. The Porsche one will provide the physical security, and the Mjaeli will be the close protection. So I wanted to make sure that I do not confuse the two.
Okay.
Sorry about
Thank
that.
You.
I see. Okay, so the 5.18 million, is that the cumulative number? So the contract was for 5.18 million, but it ultimately increased to 9.6 million. I just want to understand the time period covered by that total expense, both the 5.18 million envisaged as well as the 9.6 million. The reason this is important is that in her court papers, in the recent matter relate between the chief executive of former chief executive and the road accident fund, the then chairperson of the board stated that the limit, I think per annum, for security services was 480,000 rand. Can you confirm, therefore, can you confirm the period? Was that from 5.18 million for 1 year or for over a period of time? We just want to be able to ascertain the annual expenditure versus what is in the policy and the contract between the road accident fund and its former chief executive.
So thank you so much, Chairperson. May I just quickly confirm that, and I will provide the response into that.
Thank you. That will be very helpful. Thank you very much. And then I think lastly, Can you explain to us this fleet contract? Why was it necessary for the Road Accident Fund to hand over its vehicles to a fleet service provider and then in return for no payments? In their contract, were these vehicles priced? Was the Road Accident Fund supposed to be paid by a certain period? And do you have any idea why the Road Accident Fund has still not been paid, or whether the Road Accident Fund has made any efforts to try and secure the payment for those vehicles?
The information that we got in terms of the rationale of sending or giving those vehicles into the service provider was to avoid the attachments on the Road Accident Fund. And as a result of that, as to why the matter is not concluded to date, the information received by the investigation is that there was a delay in signing the service level agreement, and the delay can be conferred to the Road Accident Fund. And we are also still engaging with the person whom will be held responsible for that particular delay in ensuring that the service level agreement is signed. And to date, the service level agreement has not been signed, hence the vehicle are still in the hands of Fleet Data.
Are you aware of who authorized this transaction at the Road Accident Fund? Was it the board? Were there representations made to the board and so on, and the board approved, or was it at executive level, or was it some manager, a divisional manager?
Chairperson, that information has been requested because from the information that we received from the RAF, there is no indication of the person that we can say is an ultimate responsible for that. But if one is having a due regard in terms of the delegation of authority that will be applicable at a time, which will fall within the office of the CEO.
All right. Can you just describe what happened here? So these vehicles have been, so they're no longer on the asset register of the Road Accident Fund. They are on the asset register of the fleet service provider. Would I be correct in saying that?
Yes, you are correct, Chairperson. And also, just to correct what I've indicated earlier, because it's a 56 million rand that, or 52 million rand that is involved, it will be on the purview of the board. But the in terms of the e-native, the documents are, or rather the vehicle is in the name of the service provider.
Okay, so the total value of the vehicles was around 52 million, and I see that the fleet contract rate, say they wrote in slide 39, the RAF is owed what appears to me to be 5.2 million. So is that correct? Or is that supposed to be 52 million?
Right.
No, sorry, Chairperson, that's a mistake. It's supposed to be 5.2 million, not 52. Apologies for that.
It's supposed to be 5.2 million. No, it is 5.2 million. I just wanted to be certain that it's 5.2 million.
It is.
Yeah, it is. I was just confirming that it's 5.2 million.
Yeah.
So in effect, as we sit here, some company out there has been gifted vehicles to the tune of 5.2 million in terms of where the assets belong.
That's correct.
That's correct.
All right. Thank you. Thank you very much. I have no further questions at this point. But I don't know if my colleagues on the committee have any, so I'm going to look for hands. I see Honorable Beasley, your hand is up. Maybe you have a question.
Yeah, just a follow-up question with this sale and lease back. Would it not have to have gone to tender process, or and did it go to tender at all, or was it just one service provider identified? Thank you.
Thank you. That's a good question.
No, thanks, Chair. There was a tender process that led to the whole transaction. Thank you.
All right. So there was a tender process that led to this contract. Are you colleagues aware of any similar transactions? So here's why I'm asking. We invited public submissions as part of this process. One of the allegations made was that it's not just cars that are being basically sold and leased back. It is furniture, it is computer equipment, and so on, in order to avoid such being attached by the sheriff when claimants obtain a writ of execution. Have you, in the course of your investigations, come across any information that points towards similar patterns in other areas of procurement as it relates to physical assets?
Yes, Chairperson, yes. The issue of the office furniture, it is the matter, and it involves an amount to the tune of 36 million rand. So it is a matter that we are looking into, which is similar to that of the fleet.
All right. No, thank you very much. Colleagues, I'm just going to do one more scan of the hands. I don't see any. Advocate Motibi, I want to thank you and you and your team, the investigating team, as well as the team that supported this presentation and provided us with the information. And thank you for your comprehensive answers to all of the
Thank you.
members' questions. We really appreciate it. Please keep us informed of progress in your investigation.
Yes,
and
we'll do so.
hope that you will be able to finalize those discipline and other packs so that you can make some recommendations around accountability. Thank you very much.
Thank you. Thank you, Honorable Chair. Thank you, honorable members. Thank you very much.
Thank you, honorable members. Thank you. We will adjourn and convene on Tuesday.
Thank you.
Thank you, Chair.
Thank you, Chair.
Thank you, Chair.
Bye.
Recording stopped.